I think this is the 10th interested party, COFEC. It was the COFEC's argument that the public participation was conducted within the confines of the Constitution, and that the opinions of Kenyans with regard to the provision of the collection of the levy of affordable housing by the state were considered before the impugned law was enacted. Having considered the foregoing arguments, it's important that this court first dispenses with the issue on public participation being res judicata in reference to the case of appeal. The respondents have stated that the issue of public participation at the National Assembly ought not to arise in this case, as the court already determined that it was compliant with the provisions of the Constitution. Conventionally, the doctrine of res judicata is designed to bring finality to litigation and to provide parties with closure and relief from the burden of being troubled or pursued in connection with issues and lawsuits that have already been resolved by a court of competent jurisdiction. And this is the holding in the Supreme Court in the case of Kenya Commercial Bank by Muiri and Muiri Coffee Estate Limited. I will not rehash what the Supreme Court said. The Supreme Court also reaffirmed on the side case and cited the case of John Florence Maritime Services and another was the Cabinet Secretary of Transport and Infrastructure, where it goes on to explain the principle of res judicata. The Supreme Court held that a court has discretionary powers to interrogate the matter before it and determine whether it may occasion substantial injustice to the parties, and in the alternative, it must be convinced that there are special circumstances that allow it to make exceptions to the doctrine of res jurisdiction. This court has perused the appeal case and noted that the petition before the said court was pegged on the impugned notice dated 9th December 2023, issued by the National Assembly in the local dailies, requiring public participation by way of submissions of memoranda for the Affordable Housing Bill number 775 of 2023. The said court noted that the petition only challenged, this court noted that the petition only challenged this mode of public participation on the ground that marginalized communities or persons living in the slums of Korogosho, Mathare and Kibera were not able to submit memoranda in the manner prescribed. The court has also looked at the issues raised on public participation in the 6 petitions, herein vis-a-vis the issues raised on public participation in the appeal case. It is our considered view that the issues raised in the instant petitions raise a broader question as to whether public participation was conducted at the National Assembly and the Senate within the tenets of Article 10, 118, and 201 of the Constitution, while in the appeal case the issue was specific to the mode used to conduct public participation. In any event, the court found that the issue was not ripe for determination, as the National Assembly did not only require submission of memoranda but also held public hearings as a mode of public petition. And we've cited the decision at paragraph 47 and 48 and 73 of the appeal court. We find the circumstances that the issue of public participation is not res judicata, and now proceed to consider the issue substantively. It is undeniable that public participation is essential to the legislative and policy functions of government, both at the national and county levels. Public participation is integral to the legislative enactment process. Under Article 10(2)(a) of the Constitution, public participation is one of the key national values and principles of governance. Article 118 of the Constitution provides as follows: Parliament shall A, conduct its business in an open manner, and its sittings and those of the committee shall be in public. Facilitate public participation and involvement in the legislative and other business of the Parliament and its committees. Failure to ensure public participation is fatal. Any action requiring it that proceeds without such involvement is invalid, as it violates an explicit constitutional mandate. This was the holding in the case for Doctors for Life versus the Speaker of the National Assembly and others. I think this is a South African decision that is widely cited. We are certain that public involvement was crucial prior to the enactment of the Affordable Housing Act. Public participation must be authentic, not just symbolic, and should not be treated as a mere formality to comply with constitutional obligations. It is important, therefore, that this court answers what defines proper and reasonable public participation as envisioned in the Constitution. We cite the decision in the South African case of Minister for Health and another versus the New Clicks South Africa, where the South African court held that the principles of fairness are not to be applied by rote identically in every situation. It cannot be expected of the lawmaker that a personal hearing will be given to every individual who claims to be affected by the regulations that are being made. What is necessary is that the nature of the concerns of different sectors of the public should be communicated to the lawmaker and taken into account in formulating regulations. End of quote. Public participation does not necessarily mean that everyone must express their opinions. Instead, there should be tangible evidence of a purposeful initiative to incorporate a variety of perspectives in the participation program. This was as held in the case of Muiko Basin versus
and the purpose and effect of implementing the provisions of the Act. In other words, looking at the totality of the issues raised in the consolidated petition.
Virahisi uko na nafasi tatu ya kuwa milionea kila usipitwe. Cheza Daka, ushike mita yako sasa. Chagua nambari zako 4 za bahati and win up to 10 million every 20 minutes. Nenda kwenye paybill 440440 account Daka. Amount, cheza na shilingi 20 hadi shilingi 2000 na ushinde mamilioni. Daka Mita, kuwa bingwa.
Hey there friends, welcome to Kids on the Block, where fun and imagination come alive. We dive into magical world filled with exciting adventures and awesome friends.
What position were you in?
As number 2.
What position were you?
Number 1.
He decided to cross the bridge by his house and look from the other side.
We are going to do half cup of chocolate chips, and the other one we are going to do half cup of the blueberries.
So, grab your imagination hats and get ready to explore with us. Join us every Saturday at 9 a.m. for new
clerk of the National Assembly published a notice in the local newspapers inviting the public to submit memoranda. This notice was issued under Article 118 of the Constitution and Standing Order 127 of the National Assembly Standing Orders, which require the House committees considering bills to facilitate public participation. That the National Assembly reached out to key stakeholders, inviting them to participate in public hearings held across the 19 counties on various dates, and this was not the only form of public participation, as there was nationwide collection of memoranda and public meetings in chambers of both houses. That from the 9th to 16th of December, the National Assembly collected public memoranda, which was collected nationwide. During this period, Petition 103 of 2023, that's the appeal case, was filed, leading to an order from the High Court in Kisumu prohibiting public participation as prescribed by the published notice on the 9th December, pending the determination. Subsequently, the High Court in Kisumu temporarily halted the collection of public memoranda, but this did not stop the other forms of public participation which were ongoing. On 17th January 2024, the High Court clarified that its order applied only to collection of memoranda by the National Assembly. On the 29th of February, the High Court in Kisumu ruled that the notice issued by the clerk of the National Assembly was valid, dismissing the petition. The court affirmed that the National Assembly had conducted public participation in a constitutionally compliant manner. This determination by a court of concurrent jurisdiction found that the National Assembly carried out public participation in accordance with the law. Based on the court's decision, it was concluded that the public participation, that is in the Kisumu case, had been properly conducted. We note that on the National Assembly extended its invitation to stakeholders through letters dated 11th, 13th, and 29th January 2024, requiring them to make oral presentations before the committee. These sessions were held on 29th and 30th of January 2024, as well as 6th and 7th of February 2024. We further note that the National Assembly that held consultations with various government agencies, including the State Department of Housing and the National Treasury and the State Law Office, offering opportunities for them to submit representations to the Joint Committee. This is to be found in the affidavit of Samuel Njoroge, Clerk of the National Assembly. The National Assembly then reviewed the written memoranda submitted by the public and invited stakeholders. A report detailing this consideration was annexed to the affidavit of the said Samuel Njoroge and marked as SN1. The bill underwent the second reading on 15th February. During that time, debate by members of the National Assembly took place, discussing the nature and effectiveness of public participation. The ASAND report, which is annexed to the pleadings, details a report of the session of 15th February, which is attached to the pleadings here as SN2, and the documents this discussion. The bill was passed with amendments on 21st February and subsequently referred to the Senate in accordance with Article 110 of the Constitution. We also note that in line with Article 118 of 1B of the Constitution and Standing Order 145 of the Senate Roads, Transport and Housing Committee invited the public to submit written memoranda. This invitation was published in the Daily Nation, the Standard and the Star newspapers on the 23rd February 2024. These submissions were annexed to the pleadings and marked as JN1 to the Senate's response by an affidavit by Jeremiah Nyengenye, Clerk of the Senate. We note that the Senate conducted, through its Committee of Transport, Housing, also sent invitation to key stakeholders to appear before the committee for public hearings on 1st March 2024. The invitations were marked and annexed to the Senate's response as JN2. The Senate Roads and Transport Housing Committee reviewed the memoranda and stakeholder submissions.
The Senate will be the third, Senate of Kenya will be the fourth, and the Honorable AG will be the fifth. Chief William Ruto, the President of the Republic of Kenya, will appear as the sixth respondent. And the interested parties, the first interested party will be LSK as first interested party. The second one will be Professor Kithure Kindiki as the second interested party. Unless there's a party which is left out.
My Lord, just a minute. Is there anybody who has been left out on the quorum to amend consolidated petitions? Yes.
Wanjiru, Kimoto and Company Advocates. I was left out in the morning in petition E013 of 2024. I had not been notified, and therefore I learned of these proceedings on the Nation TV, and I decided to come. So therefore, yes, I came all the way from Kirinyaga because Judge Richard Mwongo was very clear that we are going to be notified once the file is forwarded before the Chief Justice. There was no communication. So we were left stranded. What is happening? And our petition is being mentioned here today. And therefore we have had to rush very fast so that I can make it in a second session, that afternoon session. Therefore, I wish yes, maybe perhaps we can
Petition E13 and E14, Kagwea.
Yes, it was consolidated and we were told that we are going to be notified. However, we were not notified. I just learned of it today on the TV at 11. So we had to rush very fast from Kirugoya so that we can understand what is happening and perhaps clarification purposes.
Is there anybody who has been left out of
my Lord, with information,
yes.
Just to draw to the court's attention, there is an application lodged on behalf of an interested party in the name of United Democratic Alliance, which can be considered at the appropriate stage. Thank you.
Intended interested party or interested party?
It's an intended. It has not been joined as yet.
on the parties?
Yes.
In the petition, I'm assuming it's one of those that you have mentioned. You have not mentioned that petition. Oh, okay. And on that score, let me say this, that in the morning, there were parties who had mentioned different petitions which were not before us. I think we should be very clear that we can only deal with matters which are before us. Should there arise a need for us to mention any matter which is not before us and which has been placed before us, we shall make that communication. So I think we need to be very clear that our jurisdiction is prescribed to particular files. Thank you very much.
My lords, your ladies, permit me to request that in is the petition, and E015, in which the Deputy President is a first interested party. Let the record of this honorable court show that we were not given an opportunity to be heard on the issue of consolidation. Let the record show the court has acted of its own volition when the normal practice, even under the Mutunga rules, is to accord parties to state their views on a proposed consolidation. This is the court's own violation. We were not asked to give our views. Thank you.
Your Lordship. Your Lordship, we have had the orders that have been granted by the court, consolidating the matters and creating another lead file. And that creates the problem we were trying to address in the morning, Your Lordship. That now this bench has created two lead files. We have which files are not before you. We have now created another lead file, E565. Your Lordship, those are some of the issues we were trying to raise in the morning, that if those other files were before you, this confusion will not be rising.
Mr. Legwa, there is absolutely no confusion. Let us not bring confusions where there's none. I think in terms of consolidation, we have cited the rule under which we have acted, Rule 17 for avoidance of doubt of the Mutunga rules. I think we need to move forward.
Yeah, and my lords, on behalf of the respondents, we confirm time has already been taken on issues that are not of any substance. Save, we would like to make two proposals. First, we would like, my lord, having read what has been filed by our colleagues this afternoon, we would like to propose that their application for recusal and this application questioning how the panel was put together should be had together for the very simple reason that they rely on the same set of arguments and facts. And I draw your attention to paragraph 5. They say that the impartiality of this court, the one we are before, has been questioned. And at the end of their prayers, they say that it is therefore in the interest of justice that this honorable court recuse itself. It would be gravely injurious to the respondents if they were allowed to prosecute this application, take one bite at attacking the court, then however the court rules, bring the other application for recusal and take a second bite. We would like to argue both of them together. Secondly, we would like an allocation of time, because it is quite clear to us that in the absence of directions allocating time, we are going to have another long afternoon of
long-winded speeches that do not address the specific issues. We are willing to say in advance that whatever time you give us, if you give 10 minutes each, we shall accept. If you give 15 minutes each, we will accept.
Professor Gibbs, which applications have been filed?
There are
how many applications?
The one you directed, my lord, in the morning.
Yes.
Yes. But it is in that application that has been filed by Jindo Matiba and company advocates. That is the application that seeks, on the one hand, that questions how this bench was appointed, and on the second hand, it requires the recusal of this bench.
So for avoidance of doubt, it is one application?
It is one application.
There are 3 applications.
There is an earlier application for recusal, and that's why I'm saying we probably can hear both of them together.
Yes.
I'm sorry, my lord, but my lordships and my lady, I just wanted to remind the court of Article 159 of the Constitution. In exercising judicial authority, the courts and tribunals shall be guided by the following principles. And 159(2)b, justice shall not be delayed. So I'm requesting your lordships and my lady to kindly refer to that provisions and let us move forward. Thank you.
My lord, let it come on record that this is the first time in which, on a matter of extreme national importance, we've been given 1 hour to be able to do an application, serve it, and come back to court. We have tried to do the best that we could in terms of complying with those directions. There, of course, one of the issues that we could not be able to do is that the written application could not be able to do full justice to the instructions that we've been given and to our case. And therefore, my lord, when Professor Gethu Muigai stands senior counsel to say that we need to be gagged on the issue of time, we protest. We shall require sufficient time. This sufficient time is not forever. This sufficient time, at least for purposes of the 3 presenting the that applications, is 1 hour. It is the least that people deserve in an applications of this nature. Second issue, my lord, is the issues of consolidations. Those issues of consolidation are as different as UDA can be from Jubilee. And the issue is, for purposes of the difference, the application under Article 165, and we did not hear you talk about the inclusions, because we've had to include. There are earlier complaint in the morning.
I'm sorry to say this.
I have.
Yes, I want to interject. If my learned friend is appealing against your orders, then there is the right forum. My lords and my lady take charge.
There is no, I'm responding to what has happened. Let us be fair to each other. And my lord, what I'm saying is this, that for purposes of those applications, the application under Article 165, because in the morning when we raised the issue orally, the questions that was raised, you are raising issues against the Deputy Chief Justice, who is not a party. She is a party now, and we have served her. We do the application on the issues of the constitutional violations regarding the empanelment of this bench. We shall need the court's directions on that issue, and we've gone through the authorities within the short period that we were here. So we are standing on solid grounds. We just need sufficient time to do our business. Issue number 2, my lord, if that applications were to succeed,
then it would effectively mean, as my learned colleague Mr. Ngoya had indicated, that then the issue of recusal of your lordships becomes academic. But if your lordships were to hold that all these serious injustices that the petitioners allege were committed by the Deputy Chief Justice are okay, then we shall now address you, the issues that concerns you. And I need to add, on the issues of authorities, because now we've been told different instructions. When we came here, we thought that while we were proceeding and taking directions, prepare the team in the office, let them prepare authorities to argue on the issue of recusal. When we were given 1 hour, we told them, oh, stop on the issues of recusal, now we are dealing with another thing. So, my lord, we cannot be able to argue, if it is today, we cannot be able to argue as expected by our client on the question of recusal. And there is no similarity of issues. Therefore, my lord, I urge you that let us adopt fair procedure. This fair procedure has always been there.
Specific application for recusal.
There are 2 applications.
Where are they?
We are not.
At least I know, Therefore, you mentioned one.
We are not.
We are actually bringing them even. One of them in number 050 is an application dated, I believe, yesterday, 21st of October. There is another one.
Okay, these are the directions we are making. We will deal with the application before us. The application for empanelment of this bench. Where's the application? Where's the application? Empanelment.
Yes.
Let's give it before you give.
Empanelment.
Yes.
Perhaps before you give the directions, with my learned friend, Ms. Kimoto, she's informing me that she was not aware of directions in the morning, that applications be filed and we come back before you. And now her petition has been integrated in the consolidated petition. That is petition.
1 hour just like the others to file her application.
Therefore, she's not been able.
So listen to this and listen to this very carefully. All of us acknowledge the momentous import of the proceedings before us. And all of us are enjoined by the rules of natural justice to do what is right. This bench is not going to be taken round in circles. We will not be taken round in circles. We are here to do justice for the petitioners, justice for the respondents. And anything which is intended to delay these proceedings will not be acceptable because both parties have come to this court under certificate of urgency. Let us be very careful how we argue our matters. We want everybody before us to get justice. That justice will not be possible if every advocate who stands up wants to take the cause in cycle. We will not allow that. I'm making final directions on this matter. The matter which we are dealing with is an application dated 22nd of October 2024 by Jindo Matiba and Company Advocates. It seeks orders under Rule 3 of the Constitution. We are dealing with the issue of empanelment. And then after that, we'll make a ruling for the way forward. So let us proceed. Let us be courteous to each other. Let us be courteous to the parties before us. Parties before us are very okay. But let's not be a theater by advocates to derail the process. I beg you. On the issue of time allocation, Judge Mureba will give the final issue directions on time.
Okay, this is how we'll proceed. The applicant.
It's only one applicant. It's only one applicant.
Of that application, we'll have 5 minutes to support that application. And the respondents will have 7 minutes each to respond to the application, as well as any other party which will want to respond to the application.
We are aware that there could be parties who, for the good reasons given, may not have filed anything. But we also appraise ourselves of the fact that the issue before the court is an issue of law. Therefore, we'll give you time to make submissions on the issue.
May I please? The clients, I and my colleagues represent the Deputy President, is the subject of the removal and the subject of his pleas to this honorable court for him not to be removed. The application for the constitutional bench is made in E015 by my friend Khaminwa, so that effectively the subject matter of removal is being given only 5 minutes. I plead with you, give us 10 minutes.
How long do you need?
20. 10 minutes. I would have said...
You have 10 minutes. You have 10.
Thank you.
Can I be heard? Yes. I received the instructions yesterday from the project here.
Dr. Khaminwa, please, you are not audible.
Oh, I'm sorry, I speak loud. I received the instructions yesterday from the project here that I come and make an application that project here would like to be joined to this matter. We all know Kituro Syria. We can't pretend that we don't know. And we know the role Kituro Syria has played in advancing jurisprudence, constitutionality, and the rule of law in this country. So I urge you respectfully that you place my name on record. Secondly, I would like also to place my name on record in my own right as an elder, as a bar, and one who has seen quite a number of things which I may not be able to say if I'm representing the profession.
That is okay. We have done that.
Thank you very much. May I then comment on one small thing? My lords, the country is in a crisis. There's a constitutional crisis. There is a national crisis. And our coming to this court is like commencing or opening an opportunity for healing in the country. And if I may say so with tremendous respect, this is not a matter where it should be allocating some 5 minutes 10 minutes, 20 minutes. No, that is not suitable. Let these lawyers talk. They are part of the healing process to the 15 million of Kenyans. A number of them are glued now to radios and TVs, trying to hear what is being said in this court. And for this honorable court to come and say that my ever friend, Mr. Mute, will only have 10 minutes, will have no 5 minutes.
Mr. Mute asked for 10 minutes and we allowed him to have 10 minutes.
He said so because he was under coercion. I have taken the trouble to read this Constitution of Kenya. I have taken the trouble to read constitutions of other countries. In fact, the way things stand at the moment, the Constitution law is evolving in such a manner that it's no longer confined only to Kenya. We can have a concept of international constitutional law. And if you read that law, including the American law, which I've taken the trouble to read, and which I've had access to it for many years.
Dr. Khaminwa, we made proposals. We gave directions. Apparently, you were not satisfied. What is your version? What would you want us? You want us to give everybody how much time?
My Lord, forget about the concept of time. Forget, where are we heading for? What are we heading for?
So,
yeah, we want the country to wake up and to revive and to give the life to the country. The country is Kenya, if you don't know what I'm talking about. Your Honor, let the lawyers say what they want to say. This should be part of the healing process of the whole country.
Dr. Khaminwa, I ask you. We have given directions on time allocation.
Your hands are not tied with respect.
Okay, tell us, just tell us, in your view, how much time do you want us to allocate parties?
I'm saying to the tremendous respect, my Lord. We talk about time in civil matters and so on. But we are dealing here with the issue of impeachment. Issue of impeachment of the deputy president. It's not a small matter at all. It's a matter that is starting the whole nation. It has paralyzed the nation.
We have heard you, Dr. Khaminwa.
Let Paul Winter be given as much time as he wants. Let the professor be given as much time as he wants. Let the Honorable Attorney General be given as much time as he wants. That is the healing process. And from this court, we shall all march forward with confidence. If I may quote Mutajo Makinata, kifua mbele na matako nyuma. Yes, I'm talking about time. Where are we going?
My Lord,
where are we going with with respect, will you sit down, please? Khaminwa is talking. Will you sit down? I don't command the matter only for yourself. Will you sit down, please? I am talking. I am on the floor.
My Lord, under the rules of this court, senior counsel has preference, speaks first before any other person except the Attorney General. So if you would please sit down. I as senior
I will not speak down. We're not practicing when you're still doing breastfeeding.
That is also true.
My Lord, what I'm saying,
finish what you're saying.
What I'm saying to you, my Lord, we need a healing process, and this court is going to provide that healing process. Let the lawyers say what they want to say. What are we heading for? Let us not have some people calling themselves professor or senior counsel titles that don't mean anything at all when it comes to this.
I think they mean something. They do mean something.
Something means something when it's you and you approve it. My Lord, all that I'm saying to you, let people talk. Let people address you. Where are we going?
People will talk.
When the country is burning.
Dr. Khaminwa, you have made your point.
Yes, thank you very much.
You have made your point.
I have made your point.
Yeah, Professor.
We have I said the Chief Justice was been removed irregularly. Let us be given time to be able to address it.
My Lord, I think those of us who are representing substantive respondents, we all agree that you have given orders that we will comply with, including my learned senior P.K. Moite, who I believe you have added some more time and he's happy with that. Maybe it would help if we informed Dr. Khaminwa that it is not the whole matter that is being heard in 10 minutes. It's a very small slice of an application on empowerment. That's all I wanted to clarify.
So, Dr. Khaminwa, I've heard what you said. We'll stick to the time allocations, but in the event that one party needs more time, they will tell us.
When we come to substantive matters, let people say what they want to say.
I agree with you.
Yeah, where are we heading to?
Thank you.
Yes.
In view of that line allocation, and I thank Senior Counsel, the senior most going by the Kenya law reports before you. May I?
By the way, mention my name. Mention
Dr. Khaminwa.
Thank you.
My Lord, even the report of the East Africa Law confirms that. My Lord, the point I need to make, and I beseech you, because of the serious time that we had to prepare this application, I could only prepare for certain aspects of these applications. My colleagues, Professor Gada, and my colleagues, Nego and Jiro. Within the 20 minutes that you have allocated, I will say my piece. It is insufficient, but I'll try. Please give Ms. Professor Gada and Mr. Ndego and Jiro 10 minutes each, and at the end, when we hear what the respondents are saying, you kindly give me, you didn't indicate, 20 minutes to do a rejoinder. That will enable us to be able to proceed without anybody feeling we want to be here forever. We don't actually want to be here forever. We want to deal with the business of the day. So that, my Lord, that does not change any time allocations by more than 30 minutes. So I urge your Lordship, I'm starting. Yes. So that I do 20 or gather 10, 20, because he has to deal with some authorities. I didn't get enough time. Then I'll do the rejoinder. My Lord, the application that is before you is dated today. It is supported by the affidavit sworn by, it is supported by the affidavit sworn by Honorable David Munyi Madenge. And for the record, all lawyers from Matiba, Ogada, Ndegwa, and myself, the record indicates we act for everybody without drawing any distinctions, because I believe there will be no time for that. So we act for all the respondents, for the petitioners, for purposes of E015. My Lord, before going on to argue this application, there is a small point that I wish to make regarding the issue of why are we having a situation where to everybody watching we seems to be following an unusual path. My Lord, there is one substantive issue of procedure that we need to point out. The petitioners are before you on account principally of the violations of the Bill of Rights. The petitioners are also here on account of the relevant provisions of impeachment. The petitioners are before you, my lords, on account of the fact that the business that the framers of the Constitution ordered, one, for appointment of a nominee to take place within 14 days, and for Parliament to do it within 60 days somehow happened within 4 hours. My Lord, those are the principal reasons why we are here. And what is the immediate context? The immediate context, my lords, and why we are here is that when petitions are filed, the duty of this court under Articles 19 all the way to 25 is to ensure that it decides whether or not the violations as alleged by the petitioners has taken place. My Lord, the way in which the law, and this is express positive law, requires that to be done is by way of a judgment. By way of a judgment is the only way that the people of Kenya would be satisfied. Have these rights been violated or not? In order to ensure that judgment, which is the express constitutional mandate, is given in circumstances that are not academic, Article 23 of the Constitution provides that conservatory orders may be given. When this matter went before your brother judges, probably a sister also, in their wisdom, they directed this matter as such enormity that we need to preserve the subject matter. That subject matter, my lord, the preservation of it would be to ensure the relevant office remains vacant until this case, through a judgment, pronounces itself. But my lord, why are we here and why is there a heated discussion? We are here and we are having a heated discussion because what is the clear intendment of the Constitution is being circumvented, so that to ensure that the subject matter is not preserved. My lord, this would be akin to a situation in which somebody comes and says, I am being evicted and my things are being removed. A court says, stop the eviction process up to where it has occurred. Then the respondent comes and says, no, lift those orders so that I can carry those things that it is alleged I was unlawfully taking. So that, my lord, in the face of the fact that what conservatory orders are supposed to serve, I beseech you, and I believe the entire country would expect that there has to be preservation of the subject matter of the application. So that, my lord, now, that being the context, it is absolutely important that we do not lose sight of the moment. It is heated, one, because there was a sitting on Saturday. Before application responses could be made, we found ourselves here. We were supposed to come here on Thursday. We are here on Tuesday. So that, my lord, and there are a lot of matters that directions must be given. So that, my lord, that context would be absolutely important, because when all is said and done, the critical issue before this court is a right under Article 25, the right to fair hearing and human dignity. Right to fair hearing and human dignity cannot be violated even during an emergency. My lord, that being the background, I ask you, and we shall be asking you, because that is the context where all these things are happening, that you ensure that whether heaven falls, the High Court must stand up, if for nothing else, for the right to preserve the subject matter until this High Court pronounces itself through a judgment. Because that is express law. Having said that, my lord, I come to the prayers. The prayers are like this. And we had already indicated. There are about 6 substantive prayers. The linchpin of these substantive prayers, my lord, is the fact that the Deputy Chief Justice, under Article 165, does not have the power to appoint or assign, as the words used by the constitutions, members of a certain court to hear the matters. My lord, Article 165(4) is very clear. Where the constitution says the president under Article 149 can nominate Kindiki, there is no argument that is made.
that a minister or somebody else can be made. We expect that there can be no feasible argument where the Constitution has expressly said that the Chief Justice shall do something. The Chief Justice in this case did not empanel this bench. My Lord, we are urging this honorable court to make a finding that unless the Constitution is interpreted or amended to give the Chief Justice, the Deputy Chief Justice, the power to empanel a bench by express reading of the Constitution, she cannot be able to do that. Issue number 2, my lords, is that it is not for nothing that it is one of the biggest occasions that the senior most judicial officer is the one that the people of Kenya, judicial power in the first place vests in the people. Judicial power by express words of the Constitution or to do this appointment and to act under Article 165 was vested on the Chief Justice. It is not by accident. It is by the express intention. So that, my lord, on the face of it, when a state officer who is not directly mandated to do something ends up doing it, under public law judicial review, it is done every day. You did not have the power under statute or the Constitution to do that. There are so many cases, starting with Madho versus Republic. I think it was sometime in 1974, where somebody at City Council did something where the law did not allow that person to do that. So that, my lord, all these cases we are aware of. So that, my lord, as far as Article 165 is concerned, we submit that that is not possible. But, my lord, this argument is developed a little bit further by the petitioner's applicants. Because the petitioner's applicants are saying that the Deputy Chief Justice, having usurped the powers of the Chief Justice, she proceeded to do two things. One, to sit at night to appoint a bench, and to authorize that bench that sat on Saturday to conduct their business on Saturday. My lord, those are irregular because, as we are saying, this is not a matter of public emergency. Of course, it was a matter of public emergency before the National Assembly and before the Senate. But because of the timelines we've given you, my lords, it is not a matter of public emergency. But having found herself in that situation, she decided to treat this matter as one of public emergency. Then, my lord, she directs come and sit on Saturday. We have set out in our applications and in our affidavit. There must be certain circumstances under our laws, the High Court Administration and Organization Act, that can justify for any bench to sit outside on Saturday and Sunday. There must be express reasons. Those express reasons, as we sit here, are aggrieved. We still do not know them. And if we do not know them, every Kenyan who would be aggrieved by a decision made in these circumstances would have every reason to be concerned that from the word go, there was a conspiracy to commit injustice. My lord, all of you have been honorable members of the High Court. There cannot be, where there is no public emergency, for occasions to arise that for the first time you would effectively be accused. You engaged yourself in a conspiracy to undermine the constitutions and to defeat it in a manner that would amount to treason. So that, my lord, the point that we make is that in the absence of a public emergency, what has so far happened is not only just unconstitutional, but something that would amount to violation of the Constitution and something that would amount to violations of the Penal Code as far as the issue of observing justice is concerned. My lord, for argument's sake, we proceed to make that argument. Let's assume that there was an emergency We submit there was none. But let's assume there was one. If there was an emergency, then it was incumbent upon the Chief Justice to read, and they were in the newspaper and in the news, all these cases that honorable judges of the High Court from various stations had recommended for a bench to be appointed to hear them, to consider them, and place them for hearing on Saturday, and to fast-track that hearing. But, my Lord, what is it that happened? My Lord, what actually happened is that you have a situation whereby the respondents, who are basically agents of the government of Kenya and its various appendages, have gotten their applications to be satisfied and for a bench to be specially convened to sit, because from the standpoint of the petitioner, to set aside the conservatory order in order, as the petitioners contend, the violations of the Constitution may be completed. My Lord, justice in this case, if it means anything, it must mean a very simple issue. The multiple violations of the Constitution that are already ingrained and embodied in the various applications, we cannot allow them to be completed, because this is what it's all about. This is what the decisions of the Chief Justice was all about, to complete the serious violations of the Kenyan constitutions. By your oath of office, your lordships are committed to stop a respondent and a government and its appendages that act in this manner. My Lord, what does it amount in law? For the Chief Justice to say you have about 15 or 20 cases, as I hear from my learned colleagues who have been in this matter longer than me. I'm here today for this matter. And I'm here because there is a constitution in Kenya. My Lord, that's being the case, there has to be satisfaction. If the Chief Justice, and she's a party in this application, cannot be able to justify why did you choose to address the grievances of the Attorney General and the government of Kenya and leave the petitioners? The first right of hearing under our constitution, I deal with Mutunga rules every day, is that the petitioner will have their rights to be heard, to prosecute their case. That is what the Bill of Rights means. The respondent, even under Mutunga rules, will respond and answer the allegations that have been made. But, my Lord, where the Deputy Chief Justice chooses to fast-track the grievances of the alleged violator, common sense has to be affected. My Lord, the conscience of this court must be bothered. Such conduct in the normal sense of things. We went through the removal of judges during those days. There was just minor infractions of the right to be heard, and judges were shown the door home. But, my Lord, here it is a systematic decision consciously made that would have very harmful effect for the jurisprudence of our country and for the meaning of our constitution. So that, my Lord, so that my learned friends can be able to speak for themselves, we are alleging that as long as the bench has been appointed by the Chief Justice, who has declined to follow the fair process for purposes of appointment of the various judges to sit, there cannot be a valid appointment. Not because I and my colleagues here would have anything on a good day before any of you, your lordships. We have done very many matters. You have courageously stand up for the constitutions in various matters. But, my Lord, unhappily, we have to be the ones saying that it would appear to a section half of this country, if not 3/4, that you have been enlisted in service of the violations of the constitutions. My Lord, that may not have happened, but that is the only way reasonable people would be able to interpret all this, particularly against the background that even the Gen Z were abducted. The substantive Chief Justice did not empanel a single bench to sit on Saturday or on Sunday. That is why this, but the context in which this matter must be viewed. My Lord, there are certain authorities. My Lord and colleagues will go through them. But I need to mention at least two things. My Lord, of course, the arguments would be made. I think there was some time back, probably in the Okiya Omtata case, my learned colleague will clarify, where the Deputy Chief Justice, the same Deputy Chief Justice, made an appointment. There was no substantive Chief Justice at that time. There was a decision that was saying this is administrative. That decision is not binding. But my Lord, more importantly, now that this issue is arising directly, this court must retire, make a very reasoned decisions to settle this issue. Whether in every other case in which the constitution or statute says so and so will do this, if that so and so does not do it, without failure, the High Courts and the Court of Appeal have always held there was no jurisdiction. An order of certiorari have always issued. It shouldn't be different in this particular matter, because the power belongs to the Chief Justice. Now, the second issue is a decisions, I believe, one of you was involved, and I believe it is a case of Okonjo Omtata versus JSC, and the decision in that decision was that at paragraph 29 to 38, basically it says that where there is a substantive Chief Justice who is a state officer, she does not cease to be a Chief Justice in this era of technology. And accordingly, the Chief Justice, the CJ, does not have authority under the constitutions to assign roles assigned to that office. So that, my Lord, in this case, even assuming that in writing the Chief Justice had assigned this role to the deputy, and that has not been alleged, it would still not be good enough, because wherever that the good Chief Justice might be, this is something that she could have done as expected her. And the people of Kenya obviously would be interested because of the nature of this matter. Why would the Chief Justice abdicate to do her job and let her deputy to do a job in a manner that aggrieves the petitioners? That is an important question, because it is the job of the Chief Justice. There is a huge mandate that is given by the Chief Justice. Do your job with the entire authority that your office carries. So it cannot just be that it is for the Deputy Chief Justice who has usurped. It is also abdication. What would be the basis for abdication? The Chief Justice not to do their job. The other case of, just 1 minute, 1 second. The other case of, I think my learned colleagues, so that it can be fast, I don't want people to knock me. My learned friend can do her. Let him do his 10 minutes, then he can do his 10 minutes.
Thank you very kindly, my lords, my lady. I'll only highlight a few issues which are legal. I'll move from Article 1 of the Constitution, your lordships. That Article 1 has created organs of government. Among them is the organ of the judiciary. And it has clearly provided, your lordship, that the people of Kenya, in exercise of their sovereignty, they have delegated their powers to those organs. In this case, the power under Article 165, Clause 4, is exclusively delegated to the Chief Justice. Your lordship, in administrative law, it's right that a person who enjoys delegated powers cannot further delegate those particular powers. In this case, in this circumstance, your lordship, it is not known to the petitioners under what circumstances the Chief Justice may have delegated these powers to the Deputy Chief Justice. It is our humble submission, your lordship, that the powers and the functions under Article 165, Clause 4 are not capable of being delegated. Further to that, your lordship, you see cleave under Article 159 of the Constitution, which provides that, your lordship, that judicial power is derived from the people. and shall be exercised by the courts and tribunals established by this Constitution for and on behalf of the people. That article again clearly indicates that this power under Article 165 Clause 4 is not capable of being delegated. How about your Lordship? In the Constitution, your Lordship, I invite you to look at Article 160 or 260 of the Constitution. It provides if a function has been created to be executed by a particular organ, it is only that organ that is capable of executing that particular function. And for the question of further delegating that particular function cannot arise so as to say that the Deputy Chief Justice had the constitutional mandate to appoint this bench to adjudicate over these particular files. Your Lordship, we have put up a case that the Deputy Chief Justice has not only violated the Constitution, but also violated the rights of the petitioners to be heard under Article 50 of the Constitution. When they move to appoint a bench of this, the bench, and fail to notify the parties herein as evidenced by the counsel appearing for the petitioner in petition number 14, it tells your Lordship that the expediency for which it was done was so as to meet the objective of setting aside the orders that were granted by your brother Justice Mwongo and your brother Justice Mwita. Your Lordship, when you retire to make a ruling of our application, it is important that you pay serious attention to paragraph 12 of our affidavit, paragraph 21 again of the affidavit, paragraph 22 again, and also paragraph 27. And then you might want to ask yourself, under Section 10 of the High Court Organizations, High Court Administration Organizations Act, how, under what circumstances, the Chief Justice, the Deputy Chief Justice, authorize you to sit on a Saturday? Under what circumstances did the Chief Justice herself, Deputy Chief Justice herself, sit at night, in the wee hours of the night, ungodly hours, and constituted this bench? Your Lordship, it's our humble submissions that Article 10 has only arrogated that function again exclusively to the Chief Justice, and that the Deputy Chief Justice has no power under Section 10 of the High Court Organization and Administration Act to order you or to authorize you to sit on an odd day like that or the Saturday. Your Lordship, permit me to draw your attention again to the case of Omtata. When you retire and the judgment will be highlighted by my learned friend, it is of importance, Your Lordship, that you look at paragraph 192 of that judgment. It has given the circumstances under which the Deputy Chief Justice can act in the absence of the Chief Justice. One is if the Chief Justice is indisposed, if he resigns, if he is dead, or if he is holded out of office. The question of leave, to which we are submitting without knowledge whether that is the circumstance that led to the allocation of powers by the Chief Justice, is not one of the grounds or reasons that the Chief Justice can exercise, the Deputy Chief Justice can exercise the exclusive powers meant for the Chief Justice. Finally, Your Lordship, all these avowals contained in our affidavit have not been controverted by the respondents through a replying affidavit. They have only filed the grounds of opposition, to which they shall bring to your attention the case of Container, which has been distinguished by the case of Okia Omtata. The grounds contained in our affidavit, Your Lordship, are uncontroverted and they must be admitted as such. I beg to rest my case.
May we request counsel to give us specific reference to Okia Omtata has been mentioned by two counsel. He's probably the most prolific litigator in the history of Kenya.
certainly be addressing my senior at the bar and senior at the academy, Professor Gido Mugai. It was a pleasure being with him in court. A man or woman who plants a tree, not knowing fully well that they will not sit in its shade, knows the meaning of life. You sit today in such an epochal moment that what you do here has significant ramifications for the Republic of Kenya. It is for you as a court to rise to the occasion. This court has defined the Constitution as a transformative constitution. And this was done by this very court, differently seated in the BBI case, David Ndii and others, versus the Attorney General. And this is what the court said about the Constitution 2010. It is a constitution of a transformative character, and this transformative character of the Constitution induces large-scale social change, including the character and conduct of politics. That the Constitution bears an internal theory of interpretation. Starting point for discerning that internal theory is Article 259 of the Constitution. That formalistic approaches to constitutional interpretation are not favored. Filed grounds of opposition, and in their grounds of opposition they raise a case, Lona Conchela and others versus the Chief Justice. That was the grounds of opposition by the Attorney General. And in that case, this High Court said that the power to appoint a bench is administrator, and that power can be performed by the Deputy Chief Justice in limited, constricted circumstances. So that the normative holder, the Chief Justice, performs it, but the Deputy Chief Justice has to perform it in certain limited circumstances. Those limited circumstances have to be demonstrable. That is Conchela. Your Lordship Justice Murima, sitting in Okoiti versus JSC and another petition, E408-2020, 2021 EKLR, I believe that is what Professor Gido Mugai was asking about. Paragraph 29 to 38. Justice Murima finds that the authority under Article 165.4 is a constitutional authority, so that authority cannot be delegated by the Chief Justice, because the Chief Justice does not cease to be a state officer, even on leave. We have another authority here, Petition 31 of 2013, Kenya Medical Research Institute versus the Attorney General. This is found at 2014 EKLR at paragraph 37. Kenya Medical Research Institute versus the Attorney General and three others, 2014 EKLR. This case at paragraph 37 says this, that the Chief Justice under Article 165.4, the authority to empanel a bench, performs a constitutional mandate. And this is not an administrative function, as was in the old Constitution. Where do we go? I'll invite the court to look at the express wordings of Article 259.3a that expressly decrees that authority granted to a specific office must be performed by that specific officer. That is Article 259.3a. I want this court to consider the decision of the Court of Appeal, and this The other side can take judicial notice of. The court can take judicial notice of. The case of Karisa Chengo, whereby the office of judge and the person of judge are synonymous. So that the Chief Justice, the person, and the office of Chief Justice are synonymous. And therefore, we cannot separate and delink the holder and the person. And therefore, if the Chief Justice were to delegate any responsibility to the Deputy Chief Justice, assuming that was possible, then the Deputy Chief Justice has to take an oath by virtue of Article 74 of the Constitution. There has to be instruments prepared authorizing the DCJ to act as Chief Justice, and for what purposes? Ladies and gentlemen, Honorable Court, the Greek tale of Ulysses, the coxswain who was asked to block his ears using wax and to avoid the temptation of alluring music, that story echoes well for you today. There's politics, there's a lot of heat and rancor, but for you, as the court, an apex court under the Constitution, yours is to uphold and defend this Constitution as required at Article 3. That's the sole mandate of this court. Thank you.
The requirements of public participation and the purpose and effect of implementing the
Article 141, Clause 1 of the Constitution provides, and I read, that the swearing in of the President-elect shall be in public before the Chief Justice, or in the absence of the Chief Justice, the Deputy Chief Justice. It's very clear. It says who must do and what will happen in the absence of that person. Article 148, Clause 4 of the Constitution provides, and I quote, the swearing in of the Deputy President-elect shall be before the Chief Justice, or in the absence of the Chief Justice, the Deputy Chief Justice, and in public. Another very clear stipulation of our Constitution of what the Chief Justice can do and what will happen in the absence of the Chief Justice. Then we go to Article 165, Clause 4. I want to emphasize one thing, my lords, my lady. You notice that Article 141, Clause 4, Article 148, Clause 4 come before Article 165, Clause 4. The makers of the Constitution were aware of what would happen in the absence of the Chief Justice while drafting Article 141, Clause 1, Article 148, Clause 4. Let us see what they said at Article 165, Clause 4. They said, and I quote, that any matter certified by the court as raising a substantial question of law under Clause 3, B or D shall be heard by an even number of judges, being not less than 3, assigned by the Chief Justice. Full stop. I'm always encouraged by an article my mentor, Professor Githu Muigai, wrote many years ago called Political Jurisprudence or Neutral Principles. Another look at the problem of constitutional interpretation. And Professor Githu Muigai makes an important argument that decisions of constitutional courts must be formulable in such a manner that they would apply coherently to all subsequent cases of similar facts. I'll not read these names in full, but you now know that if we approach this court and read for it Lena Concella, the decision already alluded to, it will appear that this court's position is this power by the Chief Justice is administrative. If we approach this court and read the case of Kemri and the case of Omtata, both of which have been referred to by my learned colleague, Mr. Gada, you'll notice that the power under Article 165 is not administrative. The court says so, and my Lord Judge Murima, you contribute that jurisprudence. It is a constitutional imperative. I think my teacher, Professor Gidu Muiga, would frown at that in jurisprudence as being political jurisprudence, because then we cannot answer first-year law student coherently. Is it administrative or is it not? We will find it difficult to answer it. Fortunately for you, as judges sitting here, you are not bound by those previous decisions, and you must come to the correct interpretation of the law in a manner that would address similar cases in the future coherently and without subjecting the judiciary to possible embarrassment. So then you will have to go and read what the two cases say, Kemri and Omtata, constitutional imperative, and what Concella says, administrative. But then you look at the eventual verdict in Concella, even when they say it's administrative, they set out the preconditions for that. And the question you want to answer is this, my lords: have those preconditions even been met, assuming even that you take it by administrative, for the Deputy Chief Justice to take up the tools of constituting a bench? Because that's the limited question that we are here to address and to guide this court. I make an argument that none of those grounds has been met. For example, we sat in this court in the morning, and I know this question will arise subsequently when we deal with the application for recusal, where my lords say, no, you know, in the virtual courts, in the virtual system, we can sit on anywhere. I'm trying to paraphrase it, my lord, so if I get one word wrong, it's not for any ill intention. We can sit at any time. We can sit from anywhere. We can sit on any day. So that, can the Chief Justice, for example, be virtually absent? Is it possible that the Chief Justice of Kenya distinguishes herself as the first person to be absent virtually? Wherever she is, at home, in Europe, in Asia, in Australia, in Kenya, wherever it is, can she be absent virtually? The answer is an emphatic no. That in the virtual space, it is difficult to justify absence. Is the Chief Justice disabled? At least, it has not been suggested by the applicant, nor the respondent, that the Chief Justice is disabled. And therefore, even looking at the Concella decision, none of the preconditions cited there to justify the limb of administrative has been met, in which case the Deputy Chief Justice has no basis upon which she could have taken up the cudgels to constitute this bench. In a virtual court, my lords, and we must be very careful about this, because I kept asking myself this morning, I've never been a judge, maybe one day I would be, maybe not, how uncomfortable it would be to sit as a judge when you perceive that some of the parties believe are uncomfortable with you. It must be a very frustrating situation to find oneself in, and my sympathies go out to all judges who find themselves in those circumstances. Just 1 minute for this argument. But the interface between litigants at the judiciary in this technology space is that we are interacting with. None whatsoever. Is the judiciary immune from the principle of transparency and accountability? It is not. If the Deputy Chief Justice makes such a consequential move as taking up the powers vested expressly in the Chief Justice, that's a matter she must, number one, expressly disclose by lodging it in the CTS for us to interact with. Number two, provide reasons for taking up that role in that direction. we ought to have seen a decision saying, for the following reasons, I take up this role of the Chief Justice, then proceed to give directions. In the absence of that step, my Lord, you have stood up as individual judges, as some of the greatest defenders of our Constitution. That character you have established in the past demands that you look at the Deputy Chief Justice in the eye and say, you may have been well-intentioned. You erred. You fell short of the constitutional standard, and therefore, by virtue of Article 2 of the Constitution, what you did was null and void. Our seating, the three of us at this bench, is null and void. We must down our tools at that juncture. Allow me to invite my senior colleague, Senior Counsel Paul Mwite, to carry forward and finish our argument. And thank you so much.
I will be very brief, my lords, your leadership. The taking of the court file 015 from Kirinyaga Court in the middle of the night was a gross irregularity that impacts on a fair trial. The bringing of that file in the middle of the night from Kerugoya to presumably the Deputy Chief Justice was another gross irregularity. For the Deputy Chief Justice to have sat in the middle of the night on Friday, the 18th of October, was a gross irregularity. The absence of communication from the Office of the Deputy Chief Justice to the parties in 015 was a gross irregularity. For your lordships and your leadership to have sat as a court outside the prescribed court days on a Saturday was a gross irregularity. The maxim that justice must not only be done, it must manifestly be seen to be done, is an extension of the right to a fair trial guaranteed in Article 50. This litany of irregularities contaminates the sitting of this bench irredeemable. And I would ask that in respect to Article 50, we do not even go into issues of recusal. Your lordships, your leadership should, on the basis of those irregularities, down your tools. There is one I have forgotten. When this honorable bench was hearing our plea for an early date, this honorable bench said the earliest date they had was Thursday of this week. So now, with this litany of irregularity, this honorable bench found time to give a hearing today when they would say they are only available Thursday. Let justice be seen to be done. The only agency that one is able to trace is that somebody somewhere is in a hurry to vacate the conservatory orders that preserve the substrata of the petitions for very weighty issues in order to swear in somebody somewhere. Yes, no, you are concerned with the Constitution. Permit me to point out, with a lot of respect, my Lord, to your leadership, I have gone through these things during the radical surgery, and I doubt that we have seen the last of the radical surgery. And my plea is that you preserve constitutionalism, you preserve the dignity of this court, because the people of Kenya are looking up to the judiciary only. Preserve that. I thank
you. May it please you, presiding judge and members of your court, we thank you for the opportunity to reply as respondents. Before I do that, I want to thank Dr. Oga. To find out whether we are with the call or not.
Yes, how many people are supporting the application? Are you parties in this matter?
For the second petitioner, in support of the application.
Your name?
This is Kemoto Teresia Wanjiru from Tess Kimoto and Company Advocates. For the second petitioner. So, perhaps you most allowed to submit or go to. Okay, thank you. So, the owner in support of the application and the fact of the matter and why we are in support of it is number one, as I said earlier, we were never served with those directions. And the fact that we were never served, this is proper procedure. That's any matter that is taken before the judge. All parties must be notified. We were never notified. So why we were never notified, and I had to learn about this issue today, I do not know. That raises eyebrows. And from the petitioner's side of view is, will this bench be impartial? Or will we be hard? Because if directions are being taken, petition E013 of 2024 is part and parcel. In fact, it was consolidated. We have not been notified. Why? Number two, the issue of fair hearing, Article 50, has been repeated over and over again. Isn't this a violation of the second petitioner's right to fair hearing? In fact, some of these applications, I'm getting them now. Yet, I should have been served before. Why the hurry? Why the rush? Why am I supposed to be served right now in court and I'm told 5 minutes submit? What is in stake? Let us all get a fair hearing. And with these preliminaries that are coming up, one is meant to wonder, will we really get justice? Petition E013 2024 was filed before petition E014 and E015.
Council, just for your information, those were your orders you got from Gregoria, where the petitions were consolidated. So that must have been your application before that court.
Yes.
So don't bring it here.
Yes. But the issue is, even after it was brought here, it is being mentioned and we are not aware. So if a matter is going to be mentioned and we are not aware, then it only shows either the bench is ignoring us, or perhaps our petition has no merit, and why so, yet we have not submitted. Let us be given a chance, let us be given audience, even to reply to the issues that are being brought forward. And we cannot reply when standing right now. I need time, I need 1 hour or 30 minutes or whatever, but I need time. So those are the issues why we are in support of this application. We feel that we are not being given a fair hearing. And the other issue that has been raised also, that the bench sat on a Saturday. We are not aware. We are learning right now. We know court operates Mondays to Friday, 8 a.m. to 5 p.m. This Saturday, when was this direction issued? Why were we not informed? So those are the bases why we are now joining hands. Though our petition has its own grounds, but then again, because of those issues, we feel if we don't raise these issues, then we might not get proper justice, because there are some people who of course are SDAs who are not able to sit on Saturday, who are not notified again, you know, those kind of issues. That's why we are wondering why the rush. Yes, maybe.
We are on the application for empanelment.
Yes. Yes. That is the issue. The issue was that, and I've also talked about it, we were never informed. And any petition, any case that will be given direction, so long as I'm in it, so long as there's a petitioner there, I have to be heard. And that is the law. And there's nothing new I'm saying. This is the procedure all advocates use. Why is it that I'm being ignored? I'm being notified 11 a.m. watching television, and I was very eager like any normal Kenyan. I see my petition being mentioned. I was very angry, but I decided to take a vehicle from Kirinyaga County quickly to come before this court and inform the court that that is not fair. That is not fair, and Article 50 has been violated. And this being a constitutional court, kindly allow us to participate fair. Yes. My colleague
Your Lordship, in the limited time that we start with. Your name, please. My name is Kirago Aduta. Within the limited time that we sat with my learned friend, Mrs. Kimoto, and despite all those challenges, we have come up with about 4 points which we request that we be allowed to submit on, since we may not have more time to file documents in support of the application. So kindly, my Lord, give me 5 minutes. Your Lordship, the powers that are given to the Chief Justice to empanel a bench, as submitted by my learned friends, is not a power that can be delegated. In constitutional classes, which we have the privilege to be tutored by Senior Counsel, Professor Gidu Muigai, he told us that there's a principle called delegatus non potest delegare. A delegate cannot delegate. So that the people of Kenya have delegated power to the Chief Justice to exercise that power. And the Constitution does not leave any room for delegation of that power. So now, we are before you, having been empaneled
by a person who does not enjoy the people's power to empanel a bench. My Lord, this is a jurisdictional question rather than an administrative question. And from the decisions which have been cited by my learned friends, Kemri, Okiom Tata, and the Conchela case, one thing you learn is that in Kemri and Okiom Tata, the court said this is a constitutional function and it cannot be delegated. When you go to the Conchela case, the court allowed or said that the Deputy Chief Justice could empanel a bench. Again, it went ahead and gave some conditions. I don't want to go through all that. But Your Lordship, what you learn again is that shortly after the Conchela decision was made, an appeal was filed in the Court of Appeal. And who filed the appeal? It is the National Assembly, who is a respondent today. It is the Senate, again, who is a respondent today, urging you to take a contrary position. What was the argument by the National Assembly and the Senate before the Court of Appeal? The argument was the Deputy Chief Justice cannot perform this function. And on the basis of that, kindly stay the proceedings before the High Court. And I'm referring to Nairobi Court of Appeal, civil application, number E097 of 2021. So the Senate and the National Assembly went and argued before the Court of Appeal. Don't allow those proceedings to go on before the High Court, because that bench, a 5-judge bench, is appointed by a person who does not have the authority to appoint. And the Court of Appeal considered that application. In the ruling, the court agreed with the National Assembly and the Senate. And the ruling does not have a paragraph numbers, but towards the end, now in finding that the Senate and the National Assembly had an arguable case, they said, as we have observed, an arguable point of appeal is not one that will ultimately succeed. The point intended to be argued whether the Chief Justice was empowered by the said article, the article we are discussing, to empanel a bench of the High Court is not an idle one. It's not an idle point. It is an arguable point. The court, on the nugatory aspect, stated that on the nugatory aspect, it appears to us that if it was to be held on appeal, that the Deputy Chief Justice had no power to empanel the bench, the appeal would be a victory with no practical effect and academic exercise. So, the court also considered that aspect which was introduced by the Supreme Court in a previous decision, the public interest consideration. And they said, we find also that this is a matter in the public interest domain, and it is proper that the appellant exhaust the appellant's rights. So the court went ahead and said that the motion succeeds and stayed the proceedings in the High Court, and to date, she has stayed. And the appeal was supposed to be determined in the certain period of time. The appeal is still pending. The proceedings in the High Court are still stayed. So you are at the place where the 5-judge bench found itself. It made a determination, it was stayed. So today, we do not have any decision where the empanelment by the Deputy Chief Justice stands. Therefore, before we proceed in these matters, kindly find that the Deputy Chief Justice does not have power to empanel a bench of an even number of judges. Thank you very much.
Your Lordship and my lady, good evening, please. My name is Akimpa. I act for the third petition in this consolidated petition, which was Khaminwa E014 of 2024. Your Lordship, I want to begin to say that the proceedings that are before this court today are fruits of a poisonous tree for the following reasons, my Lord. The first reason is that, Your Lordship, our matter was referred to the Honorable Lady Justice, the Chief Justice, on 11th of October 2024 for empanelment of a bench. Your Lordship, the same has never happened until the confirmatory orders in petition E015 were granted. It therefore shows, Your Lordship, that petition E014 as consolidated with 013 are here to seal the loophole so that we cannot question why petition E015 was brought before this court before E014. Your Lordship, I just want to agree with all the submissions by my learned friend, and that is my submission.
Can now be addressed. Hearing of matters during night hours. May I say with respect to my Lord that judges can hear matters at odd hours. I have done so. The colonial judges had cases at odd hours in the middle of the night, early hours of the morning. I remember appearing before Judges, Chief Justice Simpson, Black, Doctor, Sergeant. These would be cases with simple matters, like individuals who want bail at night because probably they have been in the bar, they have drunk a lot, and they want bail. You rush to a judge's home or the Chief Justice's home, I will be granted bail. It's a beautiful custom, beautiful practice, and I want to very respectfully, my Lord, that you endorse it in your ruling, and to give justice to people. It was a good practice. Instances like in Mombasa, Your Honor, you would have foreigners who have had children, particularly minors, with our local girls, and they want now to fly out with these little children at odd hours. They want to get to the hotel, to get to the ships at odd hours, and you would rush to a judge at night, and you would give you an order, and you go and stop it. During those days, Your Honor, something that I don't see these days, I wish it could be reinstated. You would have names of the judges in publications like telephone directories. Their telephone numbers would be there. You would know where they live. You would rush to a judge's home because you know where he lives and so on, and you would grant your orders. We no longer have that type of thing at all. I wish it could be reinstated. It was helpful. It handed down justice to the court. I recall one judge I appeared before And I think he heard me talking to his askaris at night. And he came out, shouted, "Who is that?" Somebody said, "Oh, it's a Khaminwa. He wants to come and be heard." And he shouted at me and said, "Khaminwa, I want you to know I'm not a judge during the day. I can't hear you, the time is over." And I returned and told him, "Judge, the world would be shocked to hear, or the country would be shocked to hear, you are only a judge during the day, and at night you are not a judge." My Lord, let us reinstate that practice, saying so very loud in the ruling. But then, coming to in some case, what has happened is completely wrong. Your Honor, the Deputy Chief Justice, his powers are set out in Articles 147, 148, 149, 150, 151. He has enormous powers. If a person can become a president of the Republic at any time. Your Honor, if you are going to hear his matter regarding impeachment, you should hear it during the day and should be heard in the practice. It's not a matter that can be heard at all. What the Deputy Chief Justice or whoever he is would have done is to get on the phone, to get in touch with the attorney general, get in touch even with the advocate, and ask them, "Can you come?" But he should not have heard this matter expertly. This is not a matter that can be heard expertly at all. And then also, when you look at the Constitution, my Lord, the Constitution seems very clear. I will refer you to Article 165 of Article 4. 165 of Article 4. This is information that we give to the court. It says that not 165, but Article 144, sub-Article 4, my Lord. Article 144, sub-Article 4. It says that 144, sub-Article 4. Sorry. Yeah, if you look at that 144 of Article 4, 144. Yeah, if the Chief Justice is unable to appoint a tribunal under Clause 3, the Deputy Chief Justice shall appoint such a tribunal. So you see very clearly, Your Honor, where the Deputy Chief Justice can act, it is set out in the Constitution very clearly. Now, in this particular case, it is not set out in the Constitution regarding impeachment. It does not confer power on the Deputy Chief Justice at all. If I may also refer the Lordship to impeachment officials relating to the Deputy Chief Justice. Article 144, Article 145, Article 150, Article 1B. Those provisions are expressed. Now, the next thing I may wish to deal with is, if you could look at Article 165, Article 4, 165, Article 4. 165, Article 4. It says that any matter certified by the court as raising a substantial question of law under Clause 3B or D shall be heard by an even number of judges, being not less than 3, assigned to the Chief Justice. Now, if the Chief Justice appoints 3 judges, it takes into account the number of things, my Lord. You take into account the experience of the judge that is appointed. You take into account things like whether it would probably bring a conflict of interest. we take into account whether there would be objections from certain individuals and so on, so we take to do that type of. It takes into account a lot of things. It's not just an exercise where we write down the names of judges immediately. We take into account a lot of things before we appoint one and so on. Now, in this particular case, Your Honor, this may not have, it's not power that can be delegated, the deputy chief justice at all. It is specifically and expressly delegated to the chief justice. But with the new technology we have, even if the chief justice happens to be out of the country, there's nothing that stops an individual or the legislature from getting charged and explaining to her that, look, we have got this matter coming up. There is the issue of appointing 3 judges to here. Can you have your views? And we should probably say that, look, why don't we have so and so, so and so, so and so, so and so, and should actually assign the judges to hear such matters. I would emphasize, and I also feel myself with my friends, that there has to be this kind of injustice. The deputy chief justice should not have done what he did at home. Not that you have put anything against her. Not that you are alleging that there was something that he did which is not, she shouldn't have done. There is also the issue, Your Honor, when you're dealing with matters of this kind involved, the issue of perception. Perception is important. When a chief justice performing, a deputy chief justice is performing such a kind of job or exercising such a power, what perception are other people going to get? They may read a lot into what he has done. It may be correct or it may not be correct, but there it is. They may come to the conclusion that, look, the deputy chief justice probably is acting under direction of the executive, under direction of the president. That may not have been done, but that is a possible perception. It sends the wrong perception to people. And further, when you are dealing with matters to do with administration of justice, perception is important. What signals are you sending out? And in this particular case, a matter involving the deputy president of the country is being removed under suspicious circumstances. Is it wrong people to think suspect that the deputy chief justice was probably preferred instead of the chief justice? Is it wrong people to probably entertain when they're having their task and doing that the deputy chief justice is possible that the deputy chief justice is second because he's a friend of the executive and such things and so on. So to make sure that we do not have such allegations, we stick to the law. We stick to the Constitution. So I emphasize before I sit down that what has happened is wrong, must be condemned, and the whole submission of my effort and praise. There is a word somewhere, I think in the Constitution, that the deputy chief justice may perform functions or the duties of the chief justice are absent. Clearly, that refers to cases where the chief justice may be, or the chief justice may be sick, or the chief justice may be involved in something that is cannot enable to perform the work and so on. Now, in this particular case, nobody has alleged to the chief justice from somewhere. Nobody has alleged to the chief justice of the and nobody was alleged anything that makes it impossible for the chief justice not to carry out activities at all. Again, I emphasize the first down on removal of the deputy president as shock president. And it's something that is making a number of Kenyans entertain us of interesting things and so on. Yesterday, I think it was on Sunday, was when I was sitting in my house, I decided to listen to the word of God on TV, and I sit down and I decided to listen to the word of God from a lady preacher, and he was saying that what's going on now? God no longer has any confidence in the current circumstances. Now, you can't blame her. When such things were happening, you can't blame her to have come to the conclusion that the Almighty God and Lord Jesus Christ no longer supports the current government because of such things as so. I argue very strongly, Lord, that you have called submission of my other friend, Mr. Kibe and his care colleague. They are here for submission, and it is a new one. Thank you.
May it please the court, we will try on the side of the respondents to be precise and concise. Let me start off by thanking Dr. Ogada and Mr. Ongoya for their very kind remarks about the small role I have played in the development of our Constitution and the law. Thank you very much. I also want to thank Council for the civility that has been observed in the presentation of this matter, and I do hope that the respondents will also remain civil so that we extend the proper respect that the court deserves. I am instructed by the Honorable the Attorney General, the very eminent Dorcas Oduor, our first female Attorney General, and she instructs me to inform the court that she is here because Article 156, Sub-Article 6, enjoins the Attorney General to promote, protect, and uphold the rule of law and to defend the public interest. The people of Kenya have a public interest in the maintenance of a stable government and in the protection of the sovereignty of their republic. And that republic is underpinned by having continuity in the institutions of government, be they the legislature, be it the judiciary, or be it the executive. We shall be submitting that the public interest is in favor of an expeditious disposal of matters that affect the continuity of government and that imperil the stability of the state. And that human rights are not only accorded to individual applicants, they are also accorded to the collectivity called Kenya. And the people of Kenya, they also have human rights. I agree with my learned friend, Mr. Ongoya, who is a very eminent constitutional jurist and a practitioner of the constitutional law. I agree with him when he says the Constitution 2010 in many ways is transformative has introduced more versatility in the protection of human rights. That is true. I also agree with him when he says that the Constitution must be construed in a manner to give full effect and protection to the rule of law and to human rights. But I further submit this, that the Constitution too must be interpreted so as not to create an absurdity. The Constitution must be construed so as not to create an absurdity or to put it in conflict with itself. What is the purpose of the Constitution? To establish the state. What is its further purpose? To provide for democratic government and to protect the rule of law and to protect human rights. These are not in contradistinction. These are not at war with each other. A stable government, a sovereign people, and human rights are not in conflict with each other. They are in harmony. It is the work of the court to interpret in order to create that harmony. When the court is invited to interpret the Constitution so as to create an absurdity, it must refuse to do so. This afternoon, you are being invited to interpret the Constitution to create an absurdity. Why is it an absurdity? The Deputy Chief Justice of the Republic of Kenya can swear in the President of the Republic of Kenya into office. What a huge power. What a huge authority. The Deputy Chief Justice of the Republic of Kenya can empanel a panel of judges, can appoint a tribunal to remove the president from office. What a huge responsibility. What huge authority. But wait a minute. The Deputy Chief Justice cannot assign duties to judges. Pray, my lords. What then does the Deputy Chief Justice deputize? What does she deputize? In many jurisdictions, like those referred to by the distinguished counsel on the other side, in many jurisdictions, including the United States, there is no office of Deputy Chief Justice. In the Supreme Court of the United States, there is the Chief Justice and Associate Justices. In Kenya, the drafters of our Constitution, and if I may say so myself with a bit of humility, I was one of the draftsmen. Knowing that in other countries there was no office of Deputy Chief Justice, decided in Kenya there shall be an office of Chief Justice to deputize the Chief Justice. In doing what? I'll be very brief. That is to be found in the Constitution itself and in the statute. And I think I will leave my learned friend, Mr. Ngobo, to deal with that. But let me, in the 2 minutes I've been granted by this gracious lady, make 2 points. Beneficiaries of ex parte orders stand before this court and say only they are entitled to ex parte orders. They are here to complain that they went before Judge Mongo, they went before Judge Mwita, they got ex parte orders with finality, and that was okay. But when the Attorney General went ex parte and all her prayers were refused, except the prayer to send the matter to the Chief Justice, she was wrong. How is that possible? My lords, I want you to remember, because it is in your file, the transmission from Kirigoya is in the portal. Unless my learned friends are saying they have never seen the portal itself. Yeah? The registrar in Kirinyaga, Honorable Wanyama, writes a letter, yes, saying, "Good evening, kindly find attached the document for your attention." It has a time to the Chief Justice. It is on the 18th, and it is 15:45. It is 3:45 in the afternoon. So when counsel repeats again and again, things were done at night. Well, a lie can go halfway around the world before truth wears its pants. It is not true. It is not true. The registrar sends the order at 3:45 in the afternoon. I stop there so that my learned friend may continue.
Thank you. My lords, I will take it up from there, and I will dive right into the constitutional questions. The application before you for challenging the empanelment of this bench addresses itself, my lords, to the powers of the Chief Justice under Articles 161, 2A and B, that establishes the office of the Chief Justice as head of the judiciary and of the Deputy Chief Justice as the deputy head of the judiciary. And conversely, my lords, to Articles 163, 1B, that again provides that the Deputy Chief Justice shall deputize the Chief Justice and be the Vice President of the Supreme Court. My lords and your ladyship, it is now beyond peradventure, and again quoting from the CTS, that while counsel submitted that there may be instances of delegation, they ignored, my lords and your ladyship, that the law expressly provides instances or gives direction as to when the Deputy Chief Justice shall exercise the powers of the Chief Justice. And my lords, this is expressly set out at Section 5, subsection 2A of the Judicial Service Act, Cap 185B of the laws of Kenya. The Judicial Service Act expressly provides, my lords, that the Chief Justice can deputize, or the Deputy Chief Justice will exercise the powers of the Chief Justice in the absence of the Chief Justice. My lords, the CTS and my learned friend Professor Gidu Bugai referred to this. There are only two professors, senior counsels here, so he must be correct. My lord, in the CTS, it is clear that the Chief Justice communicated to the Deputy Chief Justice that should be a way to Geneva, Switzerland, and Milan, Italy, between the 12th October 2024 and 24th October 2024. That is in the bundle. It's in the bundle. It's on record. It's on record. Senior counsel and my pupil master Paul Mwite.
Keep your voice calm. Keep your voice calm. There's no need to shout. I was asking the court whether this material is part of the court. It is. Or whether it is. That's what I was asking. You taught me to submit. And politely.
You taught me to submit clearly, and I'm polite.
You actually.
Yes, there was this paper. My lords and your ladyship, it is therefore
important that in my address to the court I indicated that the respondents in that application did not file any reply affidavit, through which this material could then be introduced before you.
My lord, it is part of the record.
The material which is in the court portal is part of court record.
Yes, my lord. Yes.
If it is not on the portal, it's okay. If the material is in court portal, it's part of the court record.
Mr. Ndegwa,
just for good order, my lords, let me make progress. Then we know, because we access the portal through particular case numbers, in which case file is this material available that we can just log in and get to see?
My lord, it is not in my place to start educating or demonstrate to Malan and friends what file to look for. Because this is the portal. I would have had no other way of accessing.
Professor, can you just give us a reference?
Yes,
for purposes of clarity.
Yes, my lord, 05, we have 3 cases that are consolidated. We have accessed the portal in E015 of 2024. A transmission from Claire Wanyama, and E014 as consolidated. We have this material and they're aware of it. We have even gone further, my lord, and served or passed on the communication to my land. It is in the public domain, my lord. We could not have secured this communication anywhere else.
Sorry, Senior Counsel, do you mean to say that what you're holding is filed on CTS?
It is.
Does it have a date and time? When the same where?
What I have here is a copy from the CTS with a reference from the Chief Justice's office.
Are you able to tell date and time?
We only accessed it from the portal.
Yes. That's so straightforward. There's an internal memo we've just been given here. My colleagues are saying it's on the portal. If we knew the case number in which it was, we would have verified it. The other option would have been for my colleagues who are reacting a particular application this afternoon, have they filed an affidavit running this document? Truth of the matter is that documents in the CTS have a timestamp, as my lady points out. The document we have in here does not have a similar timestamp. We're just saying, show us where it is so that we authenticate, then we make progress. It doesn't make sense to demean the rest of us when you're asked to authenticate. You do precisely that, you authenticate.
My lords, I can confirm that it is even in the physical file. This document in the physical file. So that my learned friends do not have it, or that they are shocked that the Chief Justice is not in the country, should be a point for response. They can respond and say, we saw the Chief Justice around. That's a possible defense. My lord, if I may, they're using into my time. They will have time to respond. Yes, the judicial report was. I can proceed.
I have a specific question. We want to know in which case file in the portal, because that's the submission my colleague has made. There's this internal memo. First, I want to know the internal memos are normally in the portal. I'll be glad to learn. But more importantly, in which case file is this internal memo so that we can authenticate? That's simple. My colleague Dan will say this in the portal. He has a duty to furnish us with the particulars.
Yes, we have indicated, my lords, that it is in the physical file. My lord, friend Mr. Nyamodi will specifically address him with that so that I can proceed, my lord. My lord,
please, the applicants, when you are submitting, the respondents gave you time. Please just give them time to make their submissions. You are going to respond. There will be time for you to make a rejoinder.
My lord, the proceedings before you are in the public interest. They are in the public interest, and therefore the question of time management, my lords, and the need for expeditious disposal of the applications before you cannot be overstated. My lords and your ladyship, time and again, my learned friends have submitted that whereas this court can sit at odd hours where it receives an application, that in matters as mundane as the current matter before you, that this court should have had this matter in the course of the day. Of course, no doubt, my Lord, this court has moved to the electronic age where matters are transmitted through mail and through other forms, my Lord. My Lord, but most fundamentally, we are here to challenge ex parte orders, not inter parte orders, not orders given inter partes. And my learned friends therefore cannot speak from both sides of the mouth that where you are dealing with matters of the impeachment of the deputy president, such as this, that ex parte orders cannot be issued, yet they obtained ex parte orders that necessitated the filing of the application before you. My Lord, what we are dealing with here is a removal under Article 145, and which the law defines as final under Article 145(7) of the Constitution. When therefore my learned friends submit about the office of the Deputy President, they seem to forget that Article 145(7) refers to the finality of the Act of Senate. And therefore, all the orders obtained under the subject, Mr. Khaminwa, just give me time. All the orders obtained under the subject of this proceeding, my Lord, were obtained after the impeachment proceedings, after the act of impeachment. And it is therefore important, my Lord, in the interest of all of us, that these matters are resolved expeditiously and timelessly, so that this court can move to the next phase. And the next phase, my Lord, would be dealing with the question of the next step. My Lords and your Ladyships, it is clear that my learned friends do not want to proceed to that phase. And that is, we have all these multiple applications and the inability of the applicants to want to be confined to the question of time. They want to speak throughout the night. On our part, we want to sanitize this proceeding, my Lord, and stick to the point that the application does not meet the threshold set out for recusal, because recusal is also a prayer in this. They have advanced no reason at all to want this court to recuse itself or to find that it was not empaneled in line with Articles 161, 163, 52A of the Judicial Service Act. We opine, my Lords, that this bench was properly constituted by the Deputy Chief Justice, exercising powers donated to her by the Chief Justice, unless they're saying that there's another Chief Justice. Thank you, my Lord.
My Lord, my ladies, as a follow-on to the submission by my two learned senior colleagues, I wish to respond further to the application as follows. There has been a lot of water under the bridge since we convened, or since this court convened at about 11:15 or 11:30 this morning. But as I am no doubt members of the court will be able to quickly figure out, the single issue that is before you is a challenge as to the regularity of this, of the referral of the 3 or 4 matters to this bench by the Honorable the Deputy Chief Justice, the Deputy Chief Justice of the Republic of Kenya. And I wish to commence my response to that objection by saying as follows. The Chief Justice occupies 3 distinct constitutional offices. 3 separate and distinct constitutional offices. First, the Chief Justice, by dint of Article 161, sub-article 2A of the Constitution of this Republic, is the head of the judiciary. By dint of Article 163(1), the Chief Justice is the President of the Supreme Court. And by dint of Article 248, sub-article 2E, the Chief Justice is the chairperson of a constitutional commission established under Chapter 15 called the Judicial Service Commission. Members of the court, I wish to take just a moment to demonstrate how the Chief Justice is deputized in these three distinct constitutional offices. In respect of her capacity as the President of the Supreme Court, Article 163, subarticle 1B is clear that the Chief Justice shall be the President of the Supreme Court, A, and that B, the Deputy Chief Justice shall deputize for the Chief Justice and shall be the Vice President of the Court. That is the first constitutional office. The second constitutional office is the head of the judiciary, and I will come back to Article 161 in a moment. Suffice it to say that it is in Article 161, subarticle 2, that the office of the Chief Justice is established. And Article 161, subarticle 2 states as follows: there is established the office of the Chief Justice, who shall be the head of the judiciary. I will come back substantively to 2B in a moment. But it is important that for the purposes of the commission established under Article 248, subarticle 2E, the Deputy Chief Justice is then not the vice chairperson of that commission. In the Judicial Service Commission, the DCJ does not deputize the Chief Justice. Now, it is our position for the respondents that the function that the Chief Justice exercises under Article 165, subarticle 4 is the function set out in Article 161, subarticle 2A. That is not the President of the Supreme Court, that is not the chairperson of the Judicial Service Commission, but that function is exercised by the Chief Justice in her capacity as the head of the judiciary. It is our submission that therefore the Deputy Chief Justice, who is the Deputy Head of the Judiciary, by dint of Article 161, subarticle 2B, can exercise the functions of the Chief Justice as Deputy Head of the Judiciary. And members of the court, Article 161, subarticle 2 creates three positions: the Chief Justice, the Deputy Chief Justice, and at subarticle C, it creates the office of the Chief Registrar of the Judiciary. Now, the Chief Registrar of the Judiciary doesn't deputize the Deputy Chief Justice, but the Deputy Chief Justice deputizes the Chief Justice. That does not require any interpretation. That is really comprehension as a matter of English. It is then for the Deputy Chief Justice, in instances where the Chief Justice is unable to act as the head of the judiciary, the Deputy Chief Justice can then perform that function. Members of the court, I submit that the decision in Lina Concella is good law. And the facts in Lina Concella are important. When you retire to consider your decision in this matter, you will note that the only respondent in Lina Concella was the Chief Justice. The only respondent in Lina Concella was the Chief Justice. If, for the sake of argument, we go along with the submissions made by our learned colleagues for the applicants this evening, that the Deputy Chief Justice then cannot deputize for the Chief Justice, then in Lina Concella, when a judge of the High Court certified that the issue in that matter was one fit and proper for an expanded bench under Article 163.4 or 165.4, then going by the argument, then there would be nobody to empanel the bench, because the Chief Justice was a party. How can he or she empanel a bench in a party where there are respondents? That is the absurdity in the argument by the other side. And my Lord, it is our submission, or it is our position, that the Constitution of this Republic must remain elegant and it must remain functional. Interpretations such as the ones urged by my learned colleagues for the applicants that would lead to that sort of an absurdity should be rejected by the court. It is my position, as I am on my feet this evening, as I have been consistent, that the Constitution says what it says. But the Constitution only means what the courts of law in the Republic of Kenya interpret it to mean. And it is the interpretation of the Constitution that gives it life, that gives it meaning. And my lords, my lady, it is therefore my submission that it is a proper interpretation of the Constitution, flowing from the express provisions of Article 161, sub-article 2A and B, that your empanelment was regular. As I take my seat, I wish to submit that I am in no doubt that as you sit as the three judges presiding over this matter this evening, you have no doubt as to the regularity of your empanelment. Because if you did, and flowing from the accolades that have been heaped upon you by learned counsel for the applicants, then you would not touch this file. There are other files that are equally urgent, that deal with the same issue, that have been brought to your attention this morning, this afternoon, and maybe again this evening, where you have said, in the absence of that direction, under Article 165, sub-article 4, you are unable to deal with those matters. So, my lord, my ladies, being satisfied, or you being satisfied with the regularity of your empanelment, this application is for dismissal. And I must add, with costs. So that the important substance in this matter can be determined by the court. I'm most obliged.
Thank you. My lords, my lady, permit me to just conclude with giving a bit of a context in the Conchela matter. I'll not go into explaining anything because, my lords and my lady, the decision speaks for itself. The decision is a decision of 5 judges of a high court. In particular, my lords and my lady, paragraph 97 is instructive. 97B in particular, if I may, reads that the exercise of powers under Article 165(4) of the Constitution, though constitutionally underpinned, is administrative in nature. They go on to add that being administrative in nature, the said mandate can be exercised by the Deputy Chief Justice, the Chief Justice is unable to exercise the mandate. At D, they conclude that in the present circumstances, the rule against bias and the rule that no person shall be adjudged in their own cause dictates that the Chief Justice, being the main respondent in the instance petition, could not assign judges to hear the petition. My lords and my lady, that is the absurdity that learned senior counsel, Professor Githu Muigai, was talking about. Take it a step further. Is it therefore their case that if, as contemplated by your their lordships in that matter, if for one reason or the other, the Honorable Chief Justice is unable to perform the functions of that office, is it therefore their case is that our learned friends from the other side have very deliberately taken to concealing what would otherwise be material information before this court. I say that for two primary reasons. I want my lords and my lady to make reference to their own application, to the grounds supporting the application. They start, the application is based on the affidavit of Honorable David Munya Matenge and other grounds. The other grounds include A, that on the 18th of October 2024, the petitioners herein filed the instant petition together with an application under certificate of urgency seeking conservatory orders restraining the assumption of office by the second interested party pending the hearing and determination of the application and petition. They go on to say that on the same day, the matter was placed before the Honorable Justice Mongo, who considered the matter, and in light of the urgency of the matter and the weighty constitutional issues raised, the Honorable Judge issued the conservatory orders sought in the first instance and certified the matter as raising weighty constitutional issues and referred the matter to the Honorable Chief Justice to constitute a bench to hear and determine the petition. This is where now the story starts. That on the next day, being Saturday 19th October 2024, the petitioners were surprised by the turn of events wherein they were served with the order of this Honorable Bench stating that the first and second respondents' applications dated the 18th October 2024, in bracket the applications for were to be had for their inter-parties hearing on the 22nd of 2024. Why do I say there is deliberate concealment of material facts? It is because, my lords, looking at the files that were coming up before this court today, that is E565 of 2024, before the court in Nairobi, and E015 of 2024 in Kerugoya, we immediately, upon learning of the orders that have been issued and which have been adverted to here, filed an application. It is on record. That application, my lords and my ladies, sought several prayers. One was that we wanted to have that application certified urgent. Like in their case, our application was certified urgent. Again, we asked that the court considers hearing the application outside the normal court hours, including a possibility of being heard on a Saturday. My lords and my ladies, that prayer was not granted by the court. We also, as a third limb of our application, asked that the court considers granting an ex parte order staying the decision of the Honorable Justice Mongo and the Honorable Justice Mwaita in the Nairobi matter. Again, my lords and my lady, that prayer was not granted. What followed was then the court, as would be the normal practice of that court, gave directions on how this application was to be dealt with. That is how we ended with the date of the 22nd of October 2024. And why this is important, lords and ladies, why is it their case that when they file an application and get orders, it is convenient, it is okay, there is justice. When they get another order in Nairobi, it is okay, there is justice. When we get an order merely certifying our matter as being urgent, then there is, all hell breaks loose. And we are saying, if only our colleagues had sought to present this material before this court, we would not be talking about what we're talking about now. It would have been manifestly clear that we were here on account of an application. My lords and my lady, I've had very strange submissions coming up this afternoon. Submissions including that at the ex parte stage where the court is supposed to be giving directions, the parties expected that the court would have been given notice. Since when, my lords, do the courts in this division, and indeed any other division, attend to matters under certificate, and at the ex parte consideration of those orders, invite parties for hearing of those orders? Why then do we call them ex parte? That submission, my lords and my lady, I repeat, is not for the consumption of this court. That submission can only go to serve an audience that is outside this court, because the people in this court are fully aware of the rules governing the conduct of matters of this court. My Lords, allow me a few more minutes just to point out a few other areas which then could speak to the reality of why then the omission of this material fact is then now being used to place this insinuation that the court either did something that was untoward, or the Honorable, the Deputy Chief Justice did something that is untoward. My Lords and my Lady, at paragraph D, the respondents in the application say, subsequent to the reference of a matter to the Chief Justice on the 18th, the petitioners reasonably expected that once the Chief Justice issued directions on the file regarding empanelment, the petitioners would also be invited for mention before the bench for directions as was directed by the Honorable Judge. If they didn't have an application, on what basis, therefore, was an order going to be issued to them? One would have expected that that would be something that would come from a party not represented. But a party represented would certainly be talking to an audience other than this audience. At paragraph G, my Lords and my Lady, they say they now have a direct accusation on her ladyship, the Honorable Deputy Chief Justice, say that the Deputy Chief Justice violated Article 1, 10, 27, and 50 of the Constitution in ordering this bench to hear and determine 3 matters in which conservatory orders had been issued against the government of Kenya and its organs, namely, there is no such order that came from a perusal of the file could speak for itself. All that the Honorable, the Deputy Chief Justice did was to constitute the bench. And if anything, this same bench is a bench that had been constituted by the Chief Justice herself. Questions that we ask ourselves. Why is it that when we appeared before this very bench last week on Tuesday, on the hearing of their own application, we sat up to midnight? Today, because it is the issue is on the other side, it becomes irregular. That cannot possibly be a parity of arms when you're dealing with a question of justice. Why is it that when they went all over asking for orders, and this speaks to why there are only 2 matters that came before this court, they filed a number of cases. In those other cases, there were no orders. What business did we have filing applications in those matters? We only felt that we were aggrieved with these orders specifically because the effect of those orders were to suspend a provision of the Constitution. And that's why it's important for us that we deal with them. As we seek to deal with them, the only way that the rules of this court establish is that we make an application. And also, my lady, I look at, finally, I think, their ground number L, that they also sought to know the circumstances that led the Chief Justice to delegate to the Deputy Chief Justice. That I think has been spoken to. My Lords, my ladies, what then comes out is that if our counterparts had been candid with the facts in the file as they speak, we would not be wasting time as we are right now. We would have had an opportunity to speak to the matters on the basis of the accuracy of the files. We would not be casting aspersions on the court as we have seen. We would not be casting aspersions on her ladyship, the Deputy Chief Justice, as we have seen. We will not be casting aspersions on the Chief Justice as we have seen. My Lords and my lady, I repeat that that submission is meant to achieve 2 reasons, and 2 reasons only. 1, to delay the proceedings that are before you today. We have an application, and at the right time we'll be seeking and insisting to have it heard. And number 2, to then create this negative impression, which I suppose is meant to be used at a later stage. I rest my case.
Thank you, my lords and my lady. My name is Morugara. I wish to submit only on 2 points of law which were actually articulated in support of the application. And these were that the proceedings before this court touch on the Bill of Rights, and they are vitally important that we should actually not be seen to flout the Bill of Rights. The Bill of Rights is Chapter 4 of our Constitution, runs all the way from Article 19 to 50. But I wish to remind the court that the Bill of Rights applies to every party that comes before the court. and it's not just one party. The proceedings we have before the court are very important to the petitioner. They are equally important to the respondents. And it goes without saying that over 50 million Kenyans actually have an interest in these proceedings, and this is the reason why the agency has been certified both ways. My judges, aspersions have been cast on the bench so as to call for this recusal and application of Article 165(4), that you're being drawn into a conspiracy to commit injustice because there is no emergency that requires you to hear this matter as a matter of urgency. Far from the truth, the two applications that are before you to set aside the conservatory order are as important as the applications that led to the granting of those orders. Therefore, the hearing of those applications must be speeded up, and we are able to move with the matter ahead. You've also been accused of being enlisted in service of the violation of the Constitution. Again, far from the truth, because this is an allegation being made against you, while the position of the respondents is that justice must be served expeditiously and as required by our Constitution. Finally, Article 165(4), which uses the word assign and not appoint. Inasmuch as this is a constitutional responsibility for the Chief Justice to assign, it is purely administrative. The word used is not appoint. We are using other words like empaneling and what have you. But, sorry, the word used is assign. And therefore, if the Chief Justice is not able to assign, nothing stops the Deputy Chief Justice from making the assignment. That is number one. Number two, where it is expressly provided in this Constitution that in the absence of the Chief Justice, the Deputy Chief Justice would act, relates to Chapter 9, when the Chief Justice is dealing with the executive. In this particular instance, we are dealing with the judiciary, where the head of the judiciary is the Chief Justice, deputized by the Deputy Chief Justice. So I also urge you to find that in fact there was nothing wrong with the Deputy Chief Justice in the absence of the Chief Justice assigning the judges who were to deal with these two applications that were before them that particular day and the next applications which had been filed previously. Thank you.
My Lord, in 2 minutes, my Lord, as you retire to consider the application, Midimo is my name, my Lord. I would invite you to consider Article 259, my Lord, Sub-Article 3, and particularly, my Lord, B and C thereof. And if you allow me, my Lord, I'll read it out. And it states that every provision of this Constitution shall be construed according to the doctrine of interpretation, that the law is always speaking, and therefore, among other things, B, any reference to, in this Constitution to a state or other public office or officer or a person holding such an office includes a reference to the person acting in or otherwise performing, my Lord, underline, otherwise performing the functions of the office at any particular time. My Lord, it's not disputed that the CJ was out of the country and that, my Lord, the DCJ was performing the functions, my Lord, of the CJ at that particular point in time. And, my Lord, our attention has been drawn to the communication from the CJ that had particularly asked the DCJ to take charge. My Lord, therefore, Article 259 3B provides an answer to the question that is before you. And And my Lord, lastly, I'll read Article 259(3)(c), which reads, my Lord, and it says, a reference in this Constitution to an office, state organ, or locality named in this Constitution shall be read with any formal alteration necessary to make it applicable in the circumstances. My Lord, the circumstances before you were that the CJ was not available to give the directions or assign the bench. What the DCJ did, my Lord, was applicable in the circumstances. I invite you, my Lord, to refer to that provision when you'll be making a ruling. I thank you.
My Lord, I represent the Speaker of the Senate. And my Lord, allow me to make very brief submissions without repeating what my colleagues have said. My Lord, allow me to start by quoting Article 145, paragraph 7 of the Constitution, to just contextualize the reasons for our application on Friday last week. My Lord, if you look at the provisions of Article 145, paragraph 7, my Lord, the impeachment of a deputy president is a serious national stability matter. My Lord, because after votes by the Senate, in accordance with Article 145(7), the deputy president, my Lord, it says at least 2/3 of all members of the Senate, when they vote to uphold any of the impeachment charges, the president shall cease to hold office. In this case, as contextualized, the deputy president, the former deputy president, in this case, Mr. Rigathi Gachagua, ceased to hold office. My Lord, look at it also in the context of Article 22. My Lord, this former deputy president, in exercise of his right in the Bill of Rights, my Lord, moved the courts by way of a petition. My Lord, on Friday, that's 18th of October, 2024. My Lord, conservatory orders were issued, which, in accordance with the petition, with the respondent's perspective, appear completely problematic. And my Lord, they required immediate intervention in terms of the respondents, my Lord, moving the court. Because, my Lord, the flip side of Article 22 is that whereas you have a right to file a case in court and seek conservatory orders in accordance with Article 23, paragraph 3A, a conservatory order which is discretionary, it means you are suing a respondent. Well, that respondent equally has a concomitant right to move to court, to interfere, to set aside, to ask the court to vary that conservatory order. My Lord, the grant of that conservatory order is discretionary. So, my Lord, there is nothing cast in stone in terms of the respondent, my Lord, coming to court to make an urgent application for the setting aside of that conservatory order. My Lord, there is also nothing strange for the court in public interest. My Lord, for the court in public interest, having looked at the grounds of this application to set aside these conservatory orders, my Lord, for the court to apply Rule 3 of the Mutunga Rules, my Lord, to make a just, expedient, and my Lord, proportionate decision in terms of directions on how to dispose of this matter. My Lord, again, under Section 60 of the Evidence Act, we all need to take judicial notice of the fact that my Lord, now we have the e-filing system. My Lord, when such extraordinary matters come to court, my Lord, the court is empowered. My Lord, at any time, my Lord, at any time of the day, my Lord, at any time, to access the system, and my Lord, to give appropriate directions for the expeditious resolution of this dispute. My Lord, they benefited from these orders on Friday. My Lord, unlike them, my Lord, we had the courtesy, because my Lord, we saw the court orders in the social media, and we responded accordingly. But my Lord, unlike them, we were courteous enough to serve the orders which were issued by this court to the respondents. So it cannot lie in the respondent's mouth to say that they have been ambushed to come to court, to the extent that they come to court and say that we are acting under protest. We did serve them with these court orders. And my Lord, on the last aspect of that point is that, my Lord, then this petition, who has come to court under certificate of urgency, my Lord, having absented himself on, at the Senate on Thursday for health reasons.
Lord, may I please on record
My Lord, I'm just winding up, my Lord, to emphasize.
Yeah, but he did not absent himself. Sickness is not absenting himself.
My Lord, I can rephrase. My Lord, I can rephrase. My Lord, this petition as well avoid it. Yes, my Lord. This petition.
My Lord, may I say he apologizes. My Lord, may I say this to you?
Let him avoid it.
May I say this to you?
My Lord, I'm avoiding
May I say this with respect to you?
He has avoided it.
My Lord, justice administered without mercy and wisdom is not justice. Here you've got someone who is in his 60s, he's saying he's sick, he has cardiological problems, and we come and play it down. These are principal advisors of the government. They must be condemned.
We have avoided it.
Can I now conclude?
Have you withdrawn that?
Yes, my Lord, I was making a contradiction by saying that the petitioner was able to access the court expeditiously, and the court was able to grant him conservative orders on Friday. My Lord, the same petitioner cannot then come to court and complain. My Lord, complain when, my Lord, the Chief Justice, my Lord, the Deputy Chief Justice, my Lord, in public interest, and given the extraordinary nature of this matter, my Lord, gives directions that this bench be constituted for purpose of determining the underlying question. My Lord, the petitioner cannot probate and reprobate, can't speak on both sides of the mouth. So, my Lord, the other extraordinary nature of this matter, my Lord, is that the petitioners have filed a multiplicity of suits. My Lord, you have heard that there were 3 cases in Ikerugoya alone. My Lord, other what is so different? What is so strange for the Deputy Chief Justice when the Chief Justice is away? Again, for the same reason, for purpose of expediency and my Lord, for purposes of laying a multiple basis for consistency in judicial decision making, for these matters to be brought before this bench by way of our directions in terms of uses being used of this matter. So, my Lord, I don't see anything extraordinary. My Lord, as I wind up, the petitioners have just simply cast aspersions to the process of appointment. There's nothing cogent. Lord, I don't see any integrity issues with respect to the handling of this matter by the Chief Justice. I don't see any integrity issues with respect to the handling of this matter by the bench. So, my Lord, our plea, my Lord, our sincere plea is that the underlying dispute with respect to the setting aside of the conservatory orders, my Lord, in accordance with the directions which were issued, shall be urgently determined, my Lord. My Lord, in public interest. Thank you.
My Lord, can I
So, my Lord, for the fifth respondent, I'll be very brief. I just wish to remind us, yes, Dr. Khaminwa, I think, the fifth respondent, for the sixth respondent now, in the new order. First, I wish to set the record straight in terms of some misrepresentations that has been made with regard to the decision cited, the Reina Conchera decision. When the petitioners were submitting, they were not aware that I am one of the petitioners in this matter, and that I am fully versed with the entire set of facts. So they misrepresented that the matter is not active. Nothing can be further from the truth. This matter is active. It was mentioned on 24th of September 2024 before a new bench that was constituted following the accession of the honorable judges who were previously dealing with it, and it is due for further mention on 30th of October 2024. So the decision remains solid in terms of its capacity to persuade you not to depart from it, because no reason has been supplied, save for the misrepresentation that it should not be utilized. Now, allow me, my Lord, to make reference to the High Court Organization Administration Act in light of the issue that has been raised on the sittings of the court. I will briefly cite verbatim Section 10 on the sittings and recess sessions of the court, where it is couched as follows: that the court shall subject to subsection 2, 3, and 9 sit continuously for the trial of criminal cases and disposal of civil and other legal business of the court. There is no disclaimer whatsoever with regard to the time that the court should sit. So the court can sit at any point in time, day or night. Indeed, today, when dusk came, I was apprehensive that counsel for the petitioners might leave, since the court is sitting past working hours, presumably. So the point that must lab home is that nothing prevents this honorable court from sitting at any time, such that the issue of when the court sat, when the files were transmitted, when the orders were released, whether on Saturday, whether on Sunday, though it has not been shown that is what transpired, the court has liberty to sit on such occasions if need be. With regard to the issue of the empanelment by the Deputy Chief Justice, again on this account, the petitioners have misapprehended the import of Article 165(4), because what is fundamental is that there be a substantial question of law, and that question of law is certified on the discretion of a High Court judge. What that means is that the same issues that are being had here today could have been had by even a single judge, if at the discretion of the judge who handled the matter reasoned that there was no substantial question of law. So what the Honorable Chief Justice or anybody else capable of exercising the powers within the office of the Chief Justice does is administrative all the High Court judges are qualified to deal with matters of such nature. All of them. So assigning one or the other is routine. It is purely administrative. There is nothing that is exceptional intellectually in terms of requiring a special exercise of powers when it comes to dealing with that aspect. So in a nutshell, I would wish that, to point out that in a hurry to come to court, the petitioners even wrongly enjoined the sixth respondent, His Excellency the President, when Article 143(2) is clear that no civil proceedings can be instituted against the President. A decision that has been affirmed by the Supreme Court in the decision of Attorney General and 2 others versus D and 79 others. So the Supreme Court made an express order that the President cannot be sued. It's an order. So the pleadings that have been lodged before this court have been filed in contempt of the Supreme Court decision, and they should amount to nothing in the full and final set of facts. So I'll be seeking that the bench continues to stay put, so that as early as possible, I can seek to have the sixth respondent discharged from the irregular proceedings initiated by the petitioners, and which they don't want concluded. They want to thrust this country into a crisis. Under Article 146, there is possibility of the office of the President becoming vacant on account of various issues, either through death, which is uncertain, through resignation, because he can tender a resignation and decide that I think I've had it too much, he can tender a resignation, or any other reason that may arise. So at the moment, upon the Senate voting on the first ground of impeachment, we stood without a deputy president. So what would happen in the event we have a vacancy in the office of the president? We are staring at a crisis. We don't have a deputy president. The Honorable Speaker of the Assembly can only serve for 60 days. We don't have an IBC. So what the petitioners are doing is fomenting a crisis of monumental proportions, which we will not be able to imagine about. So I humbly pray my Lord, my Lady, that you find favor in the arguments of the respondents and dismiss the application by the petitioners. Amos Brown.
I presume they are over. Minutes, if they are over.
But my Lord, we didn't clarify one thing. I think one of my friends have been referring to the judge at the right at Justice Murima. Justice Murima.
Well, I grew up in Nakuru. I don't have the problem of a nail and an arm. So I know it's Murima.
Are you the only person submitting now on this?
Yes, I believe I'm in my minutes, the 20 minutes. I want to do 15 minutes. They were 20 minutes, yes. And I said I'm doing 15. Mr. Ongoya will do 5. That's what I'm saying. No. He asked for 20, I'll do 15.
All right.
And the Khaminwa, because of seniority, is asking for 5. No, my Lord, I have to use 15. There were very many people who say those things. Yeah. So I need 15. I'll give Mr. Ongoya. We need 5. Dr. Khaminwa, 5.
My Lord, let me start at least for one point. My Lord, my learned colleague, Mr. Ndegwa, whom I respect a lot, is saying that probably we start with 2 points raised by a learned colleague, Mr. Joseph Kamodo. My Lord, the first thing, what is it? Okay. My Lord, the first thing is that the president cannot be sued. It's true. My Lord, for purposes of my understanding of the Constitution, everyone under the Constitution of Kenya is subject to the law. That is what the Constitution says. There is nothing the Supreme Court or any other court can say as valid law to change that position of the Constitution. So to the extent that the Supreme Court, assuming it ever said such a thing, that cannot be good law in the face of the Constitution saying everybody is under the law. Second point, my Lord, what is the nature of the proceedings? These are not civil proceedings. These are constitutional proceedings. If Article 149 of the Constitution says the President shall do this, there is nothing in Article 156 that would entitle the Attorney General to be sued on behalf of the President. Because the Constitution itself says the President shall do this. My Lord, also, if this is Bill of Rights enforcement, if the petitioners are saying the violator of the law is the President of Kenya, then the mandate of this court is to ensure the President does not violate the Bill of Rights. Nobody else can be sued on his behalf. I think we have done with that preliminary issue. Oh, and there is these issues of vacancy. My Lord, I was imagining that if this vacancy is troubling anybody in Kenya, 2 things. Number one, you would have seen some urgency in reconstituting IEBC. Some of the petitions that are before you, or that will find your way to your hands, are also saying the President cannot do what he's so desperate to do because there is no IEBC. So that is coming. So if there is any urgency, anybody who cares about vacancy, let us start with IEBC. Now, also, if, and I think Kenya are entitled to this information, Mr. Kamodo appears sorry that a vacancy in the office of the President may arise. Perhaps this is information the people of Kenya are entitled. Why is that so?
My Lord, it's purely conjectural. It's an
right. I'm not saying anything. I've ended there.
Unless you have some...
I don't know. I didn't say it. I didn't say it. Yes, but now coming to the main issue. My Lord, this forum, somebody said we are sitting past the dusk. It made me remember something. I think I saw the presiding judge was practicing at some time when I was practicing as a lawyer in the 1990s. I remember going to court very many times with Dr. Khaminwa, Paul Muite, and Gibson Kamau Kuria. What was it all about? My Lord, during that time, and when we could go to those cases, there was no distinction that was made.
My Lord, with your very kind permission, I'm constrained to just want to get some clarification. The application?
No,
because the role you have, you know it, you are supposed to be responding to the issues that have arisen. I don't think what you're speaking to has arisen, and there is no latitude that extends to that general direction. Yes. My Lord, we stand. We would want to get some guidance on that.
My Lord, I believe those issues.
Mr. Kidd, you made the clarifications earlier. Yes. But now just stick to the reply according to.
I'll do that. My Lord, one of the cases that during that time, because you can't address every true issue. I'm trying to be global. My Lord, one of the, and these are global points I'm making with regard to the issues that have been raised.
My Lord, you are effectively being told the petitioner and the respondent occupy the same space from the standpoint of our constitutions. My Lord, the truth is they don't. And I say that for the simple reason that these constitutions of Kenya was made explicitly to protect citizens who can suffer from harm from the executive and people who occupy power. That is what the protections are meant to do. Conservatory orders are given to ensure people whose rights are being violated and in need of protection, that protections will be accorded. So somebody to say that an application for conservatory orders stays on the same level with an application by a violator to continue or to complete the violations, my Lord, that would amount to misreading the Constitution. And this is not an idle issue. Under Article 20, it is very clear. The Constitution binds all state officers and this court. So the notion that we have a right to be heard, yes, when we shall be doing the petition, give them 10 hours and we shall not object. But let the subject matter be preserved. We've got no problem. The right to be heard under Mutunga rules is protected. But there is a distinction under our constitutions between a violator and the victim of violations. That one is very clear in our jurisprudence. Well, having said that, there is an oath of office. There is a question of the empanelment, whether you call it assignment, appointment. The issue is, for purposes of Article 165 of the Constitution, does the Chief Justice exercise judicial or administrative powers? I go with what Dr. Khaminwa says. These are judicial powers. And judicial powers, my Lord, takes us to the oath that is prescribed by believing the third schedule of the Constitution. When the Chief Justice says, takes an oath, it to exercise the judicial powers that includes, with regard to the High Court, the powers under Article 165(4) of the Constitution. No such oath is taken by the Deputy Chief Justice to enable her to do so. So that, my Lord, as long as, if you say it is administrative, we go to another level. The questions would be, can this be made without a formal judgment where the issue has arisen directly? Because as we were told by my learned colleague, Mr. Wadhuta, that matter is still yet to be decided by the Court of Appeal. My Lord, having said that, there is a question, my learned Professor Muigai, whom I learned a lot from him. My Lord, Professor Muigai talks about public interest, the issue of the necessity for it, and about a vacuum arising. My Lord, the happy thing about the Constitution is that up to this time, the petitioners have done nothing that would elongate the time at least of 74 to 100 days that is envisaged under Article 149 of the Constitution for this business to be conducted. If anything, it is this kind of applications to set aside that will prevent these petitions from being heard, for example, in the next 30 days, so that there is still some other 30 days for the people of Kenya to be consulted on this issue and the regular decisions to be made by Parliament. My Lord, there is an issue that an absurdity is being created. Who is creating an absurdity? The absurdity, my Lord, that is being created is this. And strictly speaking from Article 25 of the Constitution. Article 25 of the Constitution says the right to be heard is absolute, even during an emergency. How can this right ever be absolute? And this court were to take away the subject matter before that right is exercised, and you do not call that an absurdity. We are actually here to prevent that absurdity. In fact, you can have a ranking of absurdity. The biggest absurdity, my Lord, would be this, Article 125. All rights under Article 24 can be limited. Under Article 25, the right to be heard is absolute. It is binding on everybody. That's the biggest absurdity that can occur. Who supports that absurdity? The respondents. My Lord, we go next to Professor Ojienda. Of course, Professor Gedu said many things which you cannot deal with all of them. This internal memo, why is it? Oh, it's here. It's here. My Lord, this internal memo, first of all, we note, when the question was asked, is it anywhere? It is not in the CTS. Start with. Number two, or portal for the cases that have actually been filed. My Lord, the second issue, there is no replying affidavit for this court to be able to deal with it. But what does it actually say? It says, during my absence, I request you, your lordships, to be in charge. I will, however, be available on email or telephone for consultation. My Lord, the last sentence, plain meaning of English, would mean to me that Chief Justice from Geneva or anywhere else she was cannot be able to carry out certain administrative functions. But when she says that to be consulted, this was clearly made in the knowledge that there are certain things that I must do, notify me, so that I can do them. The appointment of judges could be made by the Chief Justice in accordance with the constitutions from Geneva. My Lord, I could have said more. There is no much time. My Lord, they say they are challenging ex parte orders. My Lord, what ex parte orders is the main issue. The ex parte orders we are challenging is a conservatory order to ensure that before this court there will be integrity and the constitutions will be upheld. And the kind of circus we had in Parliament will not happen before you. My Lord, my Lord, for purposes of where do we want this matter to be completed? My Lord, they said this is that they want the matter to be completed. We are more desperate for this matter to be completed. And that is why in the expectation of the petitioners, we expected that the first business of this court, like it happens every time I sit on benches, and I've sat on very many, they say, this matter is very urgent, we cannot hear preliminary matters, let's go straight to the petition. So we are very desperate to have this matter heard. My Lord, there is my learned colleague, Mr. Nyamodi, whom again is a good friend of mine I respect. CJ occupies 3 constitutional offices, I agree. But the only issue of distinction is, under Article 165(4) of the Constitution, she cannot be able to perform that functions any more that we could say she could transfer judges. Transfer of judges is actually more or less administrative, but she doesn't do it because it is an important office that goes with the office of the Chief Justice. But if this is judicial, she cannot be able to do it. My Lord, the issue of Conchela, again, the issue is contextual. The Chief Justice was a party, and therefore in Conchela, as far as I am concerned, the matter, the Deputy Chief Justice did so as an acting Chief Justice. Even Gachagua or anybody else who gets into that position, when they are acting as acting president, there are certain decisions that they can make, but they must wear that position. In this letter, there is nothing that suggests that the Deputy Chief Justice was turned into an acting Chief Justice by the CJ. Equally importantly, there is no express delegation that my powers under Article 165(4) would now be performed by the Deputy Chief Justice. My Lord, the issue of Gumbo came with some funny issue on concealment of material facts. I do not know, I struggled to listen that we have concealed anything. Now, as anything, we actually even did an affidavit. They had the right to do an affidavit. It is not indicated that this document, which was in our possession, as I understand the law of disclosure, we failed to disclose it. All the other issues they are raising are points that are in contention. That does not amount to concealment, as I understand it within the law. My Lord, there was the question that no basis for Getonga Murugaro. Getonga Murugaro, I'm trying to rush. Murugaru? Okay. Murugara, okay. That's very sorry. Oh, that's okay, my friend. My Lord, he says, and I agree with him, that this matter is very important for the 50 million Kenyans. I could not agree more. A matter that is so important to 50 million Kenyans, the least that could be expected is that proceedings are going to be conducted in open, without suspicions, without undue hurry and pressure. But my Lord, if the petitioners, and already they are feeling, I'm feeling pressure that I started today, if the petitioners feel that they are under pressure in a certain matter, that is not an express emergency under the constitutions of Kenya, it leaves a big question mark. If for some reason there is a desperation to turn businesses that the Constitution say you should do it within around 80 to 100 days into 4 hours, there's a big problem, and that must be addressed. I'm about to finish. My Lord, so that for purposes of those issues, I agree with him. It just points out to the care that must be taken that these proceedings are not misunderstood. This court in particular must not be understood that it was under undue influence, that we must wear somebody Wednesday, Thursday, or something like that. This must be done within the four corners of the Constitution. If that one is not done, my Lord, there would be a huge problem, not just of perceptions, but the huge problem that in Githongori versus Republic, they were talking about. The world, Africa, and everybody else is watching. And what are they watching? How are we going to consider to reduce time, for example, that is expressly set out the Constitution into hours? And to do what? To prevent a victim of constitutional violations from urging petitions that are before the court. That should worry the court more. 2 points that are remaining. Mr. Wanyama, I have to choose between Wanyama. Oh, Wanyama is the last one. My Lord, the issue of Wanyama is national stability. He made several points. That is probably the only one I will address myself. Ms. Angoya can do the rest. This issue of national stability is actually very important. I agree with him. The issue of the impeachment of the deputy president raises the issue of national stability. For the simple reason, and this is why we must hear the petition, the deputy president, my lords, and as we understand elections in this country and the Political Parties Act, was not just a holder, the way you can appoint Kibe Mongai to be a legal officer somewhere. He was not just a holder of the office of deputy president. There was a political process in order to be able to get power under the Constitution in the 2022 election. That's why the national issue of national stability arises. His supporters and also the president, they came together to form a party. So that, my Lord, over and above, and there is a case which I was privileged to do in 2013, one of the lawyers in that case, this one of conflict management, when Ruto and Uhuru were being prevented from running for presidency in 2013, that case, my Lord, and we did it before 5 judges, it was civilized, it was decent, there was no hurry. But more importantly, what was the issue there? Part of the issues that I was present in that case to urge is this, that President Uhuru and the now President Ruto are not seeking this case by themselves, because Article 38 of the Constitution says they are doing this. The peoples in exercise, their supporters, in exercise of their rights, political rights, and Article 38, prefer these people to be their candidates. So what's my point? My point is this: look beyond Rigathi Gachagua. Look also to the people who feel we've not been given a square deal, and we are being disenfranchised, we are being emasculated from the political scene. We shall urge that more during the hearing of the petitions. For now, let us hold the ring. Let us not take away the ring, so that we can meet sometime next week, my Lord, and deal with the issue. My learned colleague, Mr. Ongoya, can take on from there. No, my lord, I have finished.